27/7 ಜುಲೈಯಾ 27/7
ಇವಾಗ ಜುಲೈ ಈಗ ಇನ್ನು ಜುಲೈ ಎಷ್ಟು ಇವತ್ತು 3/7 27
ಮೇಡಮ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಹೇಳಿ 27ನೇ ತಾರೀಕು ಆಗಿದ್ದದು
27ನೇ
ಅದ್ರ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಯಾವಾಗ ಕೊಟ್ರು
ಇವತ್ತೇ ಅನ್ಸುತ್ತೆ ಇವತ್ತಿಗೆ ಇದೆ ನನ್ನ ಡೇಟ್ ನಾವು
ಅದೇ 12/6/99
ಇರ್ಬೇಕು ಅದೇ
ಅದು ಯೂಶಲಿ ನೋಡಿ ಬಂದ್ಬಿಟ್ಟು ಇವಾಗ ನೋಡಿ ನೆನ್ನೆದು ಒಂದ್ ಹೇಳ್ಬೇಕು ನೀವು ನನ್ಗೆ ನೆನ್ನೆದು ಎಷ್ಟು ಡೇಟ್
15
ನಾನ್ ಕುತ್ಕೊಂಡ್ ಮಾಡ್ಬಿಡ್ತೀನಿ ಅವತ್ತೇನಾಯ್ತು
ನಮ್ಮ ವರ್ಕ್ನ ಈ ತರ ಆಂಪರ್ ಮಾಡಿಸ್ತಾ ಇದಾರೆ ನೀವು ಮೇಡಮ್ ಹತ್ರ ಮಾತಾಡಿ ಅಪ್ಪ ಈಗ ಬೆಳಗ್ಗೆ ಅವ್ರು ಆಕ್ಚುಲಿ ಯೂಶುವಲಿ ಬೆಳಗ್ಗೆ ಕಸ್ಟಮರ್ ಎಲ್ಲ
ಅದೇ ಮಾಡೋದು ನಾನು
ಬಂದ ತಕ್ಷಣ ಓಡು ಅಂತ ಬಂದು ನಿಂತು ಬಿಟ್ರೆ ಏನ್ ಕೆಲ್ಸ ಅಪ್ಡೇಟ್ ನಮ್ ಕೆಲ್ಸನೇ ಮಾಡಕ್ ಆಗ್ತಾ ಇಲ್ಲ ನೀವು ಮೇಡಮ್
ನಿನ್ನೆ ಚೇಂಬರ್ ಅಲ್ಲಿ ಇತ್ತಲ್ಲ
ನಾನು ಹೇಳಿದ್ದೀನಿ ಇಲ್ ಬಿ ಅರಾಸಿಂಗ್ ನಮ್ಗೆ ಒಂದು ಮೇಡಮು ಇನ್ನು ಕಾಯ್ಕೊಂಡು ನಿಂತ್ಕೊಂಡು ಬಂದು ಹೋಗು ಓಡಿ ಅಂತ ಅಂದ್ರೆ ನಮ್ಮ
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 33 ಏನ್ ಡೇಟ್ ಕೊಟ್ರಿ ನಿನ್ನೆ ಚೇಂಬರ್ ಅಲ್ಲಿ ಆಯ್ತದ
5 PM ಚೇಂಬರ್ ನಿನ್ನೆ
ಅಲ್ಲ ಮೇಡಮ್ 5 PM ಅಡ್ಜನ್ ಆಗೋಯ್ತು
5 PM
33 ಏನಾಯ್ತು ಚೇಂಬರ್
33 15/7 ಅದುವೇ
ಓಕೆ 15
ಎರಡು ಕೊಟ್ಬಿಡ್ನಲ್ಲಪ್ಪ
ಇದು ಬಂದು ಇವತ್ತಿನ ಡೇಟಾ ಅವತ್ತು ಅಪ್ಡೇಟ್ ಆಗಿಲ್ಲ ಅಂದಿರೋದು
ನಾನು ಅದೇ ಅನ್ಕೊಂಡೆ ಯಾವ್ದೋ ಒಂದು 15/7 ಹೋಯ್ತಲ್ಲ ಅಂತ ಹುಷಾರು ಈಗ ಎರಡು ಮಾಡಿಸ್ತಿದ್ದೀನಿ
ಇದು ನೋಡ್ತೀನಿ 27/7 ಯಾವ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ ನಾನು
ನಿನ್ನೆ ಮ್ಯಾಡಮ್ ಹೇಳಿದ್ರು
3/7
ಇವತ್ತಿಗೆ ಅಪ್ಡೇಟ್ ನಮ್ದು ಅದು ಬಂದ ತಕ್ಷಣ ಅಪ್ಲೋಡ್ ಮಾಡ್ತೀನಿ ಇಲ್ಲ 10:30ಗೆ ಮಾಡಿಸ್ತೀನಿ ಬಂದ ತಕ್ಷಣ 10 ಗಂಟೆ ಬಂದ ತಕ್ಷಣ
ಸರ್ GMFC ನಾ ಇದು ಲಾಸ್ಟ್ ವೀಕ್ ಕೊಟ್ಟಿದ್ರಿ ಅಲ್ವಾ ನೀವು ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರ ಏನು ಎಲ್ಲಿದೆ ಬ್ರಾಂಚ್ ಇದು ಫೈಲ್ ಎಲ್ಲಿದೆ ಒಟ್ನಲ್ಲಿ ಇದೆಯಾ ಪೆಂಡಿಂಗ್ ಇದೆ
ಇದು 15/7 2 PM ಮಾಡಿಸ್ಬಿಡ್ಲ ಅಂತ ಕೇಳ್ಕೊಳ್ತೀನಿ ಮಧ್ಯಾಹ್ನ 5 PM ಅಂತ ಆಗೋಗಿದೆ ಇದು ಬರ್ದು ಬಿಟ್ಟು ಸೈನು ಆಗೋಯ್ತೆ ಆಗಿದೆ SN ಇದು ಏನಾಗೋಗ್ಬಿಟ್ಟು ಆಮೇಲೆ ಅಲ್ಲ ಅವತ್ತು ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡು ಪೋಸ್ಟ್ ಮಾಡ್ಸೋವಾಗ ಏನ್ ಗೊತ್ತಾ ನಮ್ಗೆ ಏನೋ ಮೈಂಡ್ ಇಟ್ಕೊಂಡ್ ಬಂದಿರ್ತೀವಿ ಬೆಳಗ್ಗೆನೆ ಬಂದು ಯಪ್ಪನ್ ಕಾಟ ಅಂತ ಶನಿ ತರ ಒಪ್ಪಿಸ್ಕೊಂಡ್ಬಿಡ್ತಾರೆ ನಾನು ಏನ್ ಗೊತ್ತಾ ಇವಾಗ ಅಲ್ಲಿ ಅವತ್ತು 7:30 ಅವತ್ತು ಗೊತ್ತಾ ಲೇಟ್ ಆಗೋಯ್ತು ಅವ SK ಪ್ರತಿಮಾ ಅನ್ಸುತ್ತೆ ಲೇಟ್ ಆಗೋಯ್ತಲ್ಲಿ ನನ್ಗೆ ಅಲ್ಲೇ ಲೇಟ್ ಆಯ್ತು ಮನೆಗೆ ಹೋಗೋ ಅಷ್ಟೊತ್ತಿಗೆ 8 ಕಾಲ ಅವತ್ತು ಸುಮ್ಮನೆ ಶನಿ ಮುಂದೆ ಮುಗ ಅದೊಂದು ಅಪ್ಲೋಡ್ ಆಗ್ಲಿಲ್ಲ ಅಂತ ನಿನ್ನೆ 8 ಕಾಲ್ ಅನ್ಸುತ್ತೆ ಇನ್ನು ಚೇಂಬರ್ ಅಲ್ಲೇ ಇರ್ಬೋದಲ್ಲ ಬೇಡ ಚೇಂಬರ್ ಅಲ್ಲೇ ಫೋನ್ ಮಾಡ್ಬಿಟ್ಟು ಅಪ್ಲೋಡ್ ಮಾಡಕ್ ಆಗ್ತಾ ಇಲ್ಲ ನೀವು ಅಪ್ಡೇಟ್ ಮಾಡಿಲ್ಲ ನೋಡಿ ನಾವ್ ಹೆಂಗ್ ಮಾಡೋದು ಹಿಂಗೆಲ್ಲ ಮಾಡಿದ್ರೆ ನೀವು ಅಂತ ಹೇಳ್ದೆ ಇಲ್ಲ ಇವತ್ತೊಂದಿನ ಏನು ಮಿಸ್ ಆಗಿದೆ ಯಾವಾಗ್ಲೂ ಹಂಗಾಗಲ್ಲ ನೀವು ಫಸ್ಟ್ ಪ್ರಸಾದ್ ರೌಂಡ್ ನಿಲ್ಸಿ ನಮ್ ಕೆಲ್ಸ ಮಾಡಕ್ಕೆ ಬಿಡಲ್ಲ ಅಯ್ಯಪ್ಪ ಈ ತರ ಎಲ್ಲ ಮಾಡುತ್ತೆ ನೋಡಿ
ನಾವು ಒಂದು ಇಲ್ಲ
ನಾನು ಹೇಳಿದ್ದೀನಿ ನಮ್ಮ ವರ್ಕ್ ನಮ್ದು ರೋಟೀನ್ ವರ್ಕ್ ಒಂದಿನ 2 ದಿನ ಮೇಡಮ್ ಹೇಳಿದಾರೆ ಆಕ್ಚುಲಿ ಮೇಡಮೇ ಹೇಳಿದಾರೆ ಈ ಲೆಟ್ ಹಿಮ್ ಟೇಕ್ ಪರ್ಮಿಷನ್ ಆಫ್ ಮೀ ಇಫ್ ಹಿ ವಾಂಟ್ಸ್ ಟು ಪೋಸ್ಟ್ ಫಾರ್ 1 day 2 days ಲೀವ್ ಅಂತ ಏನ್ ಹೇಳಿದ್ರು ಕೇಳೋದಿಲ್ಲ ಅಯ್ಯಪ್ಪ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ನಮ್ಗೆ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಇದೆ
ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ನಮ್ದು ಫಸ್ಟ್ ಪೋರ್ಟಲ್ ಇದಿತ್ತು ಕಾಮೇಶ್ವರ ಸರ್ ಬರೋಕ್ಕಿಂತ ಮುಂಚೆ ಡಿಪಾರ್ಟ್ಮೆಂಟಲ್ ಎಕ್ಸಾಮ್ಗೆ ನಾನು ಲೈಬ್ರರಿ ಬುಕ್ ತಗೊಂಡಿದ್ದೆ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಆಫ್ ಇಂಡಿಯಾ ಅದು ಓಲ್ಡ್ ವರ್ಷನ್ ಇತ್ತು ಅದಕ್ಕೆ ನಾನು ಆ ಬುಕ್ ನ ಪೋರ್ಟಲ್ ಬಿಟ್ಟು ಇಲ್ಲಿ
ನಮ್ ಪೋರ್ಟಲ್ ತಂದು ಕೊಟ್ಬಿಟ್ಟು ಎತ್ಕೊಂಡು ಹೋಗಿ ಬಿಕಾಸ್
ಇದೆ ಅದಕ್ಕೆ ಅದೇನೋ ಅಲ್ವಾ ಬುಕ್ ಒಂದ್ಸತಿ ನೋಡಿ ಇಲ್ಲಾಂದ್ರೆ ನಾನು ಲೈಬ್ರರಿ ಹತ್ರ ಮಾತಾಡ್ತೀನಿ
ಪೋರ್ಟಲ್ ನಂಬರ್ ಎಷ್ಟು
23 ನಮ್ದು ಮುಂಚೆ ಇದೆ ಇತ್ತು ಪೋರ್ಟಲ್ ನಂಬರ್
ಅಲ್ಲೇನ್ ಹಾಕಿದ್ದಾರೆ ನೀವು ಲೈಬ್ರರಿಗೆ ಎತ್ಕೊಂಡು ಹೋಗಿದ್ರಾ ಅಲ್ಲ ಅವ್ರಿಗೆ ಇಂಟಿಮೇಶನ್ ಕೊಟ್ಟಿದ್ದ
ಕೋರ್ಟ್ ಆಫೀಸರ್ ತಗೊಂಡಿದ್ದೆ ಮೇಡಮ್, ನಮ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದೆ ಇತ್ತವಾಗ.
ನಾನ್ ತರ್ಸ್ಕೊಂಡಿದ್ದೀನಿ ಅನ್ಸುತ್ತೆ ಬೇರೆ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್
ಇಲ್ಲ ಇದೇ ನನ್ ಬುಕ್,
ಹಾ?
ಇದು ನನ್ ಬುಕ್. ಇಲ್ಲಿ ಇಲ್ಲ ನೋಡಿ, ಕೋರ್ಟ್ ನಂಬರ್ 23.
ನಿಮಿಷ ಎಲ್ಲ ಕೊಡಿ, ಅದ್ ಕೊಡಿ.
ಇಲ್ಲ ನಾನು ಅವ್ರಿಗೂ ಹೇಳಿದ್ದೆ, ನಮ್ಮ ಕೋರ್ಟ್ ಆಫೀಸರ್ಗೂ ತಗೊಂಡಿದ್ದೀನಿ. ಇಲ್ಲಿ ನೋಡಿ, ಇದು ಲೇಟೆಸ್ಟ್ ವರ್ಷನ್ ಇದಕ್ಕೆ ತಗೊಂಡಿದ್ದು ಪದ್ಮಶ್ರೀ. ಇದು ಅಮರನಗರ ಸೇರ್ಚ್.
ಪದ್ಮಶ್ರೀ ಅಂತ ಚೆನ್ನಾಗಿರ್ತದೋ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಆಫ್ ಇಂಡಿಯಾ 23ನೇ ಕೋರ್ಟ್ ಆಲ್ದು ಎತ್ಕೊಂಡು ಹೋಗ್ಬೇಕಂತೆ ಡಿಪಾರ್ಟ್ಮೆಂಟಲ್ ಎಕ್ಸಾಮ್ಗೆ. ಈಗ ಅವರು ರೀಪ್ಲೇಸ್ ಅದು ಇಲ್ಲಿರೋ ಬುಕ್ ಅಂತ, ಅವ್ರು ಇಲ್ಲಿರೋ ಬುಕ್ ಅವ್ರಿಗಂತೆ. ಅವರು ಕೋರ್ಟ್ ಆಫೀಸರು ಮತ್ತೆ ಲೈಬ್ರರಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ವಿ ಅಂದ್ರು. ಅದಕ್ಕೆ ಇವಾಗ ಅವ್ರ ಬುಕ್ ಅವ್ರಿಗೆ ಕೊಟ್ಬಿಟ್ಟು ಟೋಟಲ್ 23 ತಂದಿಯಾರ ಅವ್ರು ಇವಾಗ. ಅದನ್ನ ನಾನು ರಿಪ್ಲೇಸ್ ಮಾಡ್ಬಿಡ್ತೀನಿ.
ಇದು ಓಲ್ಡ್ ವರ್ಷನ್ ಇದೆ, ಇದು ನ್ಯೂ ವರ್ಷನ್ ಇದೆ.
ಕರೆಕ್ಟ್.
ಅದಕ್ಕೆ
ಅದಕ್ಕೆ ಒಂದ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ಬೇಕು. ಅದು
ಡಿಪಾರ್ಟ್ಮೆಂಟಲ್ ಎಕ್ಸಾಮ್
ನಾವು
ಅಪ್ಡೇಟ್
ಅವ್ರು ಏನ್ ಗೊತ್ತಾ ಇವ್ರೆ, ಒಂದ್ ನಿಮಿಷ ಹೇಳ್ತೀನಿ ಕೇಳಿ. ಕೋರ್ಟ್ ಆಫೀಸರ್ಸ್ ಬುಕ್ಸ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೋದ್ರೆ ಏನ್ ನೋಡು.
ಆಮೇಲೆ ಈ ನಂಬರ್ ಬರ್ಕೊಂಡೆ ಬುಕ್ ಕೊಟ್ಟಿರ್ತಾರೆ ನಂಗೆ ಲೈಬ್ರರಿಲಿ. ಇದ್ರ ನಂಬರ್ ನೋಟ್ ಮಾಡ್ಕೊಂಡೆ ಕೊಟ್ಟಿರ್ತಾರೆ. ನಾನ್ ಬೇರೆ ನಂಬರ್ ತಗೊಳಲ್ಲ.
ಅದು ಅಪ್ಡೇಟ್ ಆಯ್ತು ನೋಡು. We have uploaded. ಅಲ್ಲಮ್ಮ 15th ಅಂತ ಹೇಳಿದ್ರು. Actually there are 2 matters on 15/7. So let us ask madam. Any discussion ಕೊಟ್ಟಿದ್ದು 15/7 ಅಂತ ಹೇಳ್ತಾರೆ. Serial number 53. 15th madam told, but already one matter is there on 15th. Let us clarify it. Wait. I wait it for up to 7:30 we wait and come to 10:30. 1943. ಏನ್ ಬುಕ್ ಇದು? ಏನ್ ನೆಂದೋಗಿತ್ತ? ಇದೆಯಲ್ಲ ಇದು ಲೈಬ್ರರಿಗೆ ಹೋಗಿ ಪ್ಲಸ್ ಮಾಡಿಸ್ಕೊಂಡ್ ಮಾತಪ್ಪ. ಇದು ಒದ್ದೆ ಆಗ್ಬಿಟ್ಟಿದೆ ಬುಕ್ ಮೇಡಮ್, ಮೇಲೆ ಇಡಕ್ಕಾಗಲ್ಲ ನೋಡು, ನೀರ್ ಬಿದ್ಬಿಟ್ಟಿದೆ. 927 ನೀವ್ ಹೇಳಿ ಅವ್ರಿಗೆ, ಇದು ನೀರ್ ಬಿದ್ಬಿಟ್ಟಿದೆ, ಇದು ವಾಪಸ್ ಕೊಟ್ಬಿಟ್ಟು ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಆಫ್ ಇಂಡಿಯಾ ಬೇರೆ ಲೈಬ್ರರಿ ಮೇಲೆ ದಯವಿಟ್ಟು ಕೊಡ್ಬೇಕು. ಅವರು ಮೇಡಮ್ ಇದ್ ಮಾಡ್ತಾರೆ.
Hello, court officer madam. Court officer madam. Hello. Madam, unmute ಆಗಿದೆ, ನೀವು ಮಾತಾಡೋದೆಲ್ಲ ಕೇಳಿಸ್ತದೆ ಎಲ್ಲರಿಗೂ. ಯೂಟ್ಯೂಬ್ ಅಲ್ಲೂ ಇದೆ.
Portal is not muted. What you want, you tell madam.
Not what I want, madam. Everything that you all spoke so far is already recorded. I am
What?
telling for your benefit. If you
Ah.
are going to behave like this, then somebody will report it.
What? Hello? ಏನಂತ? ಏನೇ ಬಿಡಿ. ಯಾರು ಮಾತಾಡ್ತಿರೋದು? ಮೈನ್ ಕಂಪ್ಯೂಟರ್ ಅನ್ಸುತ್ತೆ. The reconciliation matter is listed today, no? Yesterday's matter is the date ever updated, no? You give that file to me, okay? Sada will come to saying that. You give that file to Sada. I guess it is listed today because in the late hours it is listed, no, corrected and listed. And that matter. Yes, the file is corrected. You upload it and you give that file to Sada. See connection. Then no, that matter not yesterday's matter. No, 27 matter. That order is order done. File 373. Okay, the order is listed today. Yesterday evening it is corrected and listed. That file is listed. Okay, order closed. Sorry, everything is failed. 40, 41, 55, 22.
that day,
Please, my lord.
the writ petition is, a memo is filed, seeking to withdraw the writ petition.
Lord, CL number 36, my lord. Withdrawn.
30?
36.
Ah.
Withdrawing.
Same.
He has not paid maintenance for the last. There are arrears.
Give the memo to the court officer. 36 also say, give the memo, we'll see.
There is an action of jewelry. She has taken gold loan. My lord. It is-
We will see the memos. Yes.
Submission, my lord. Serial number 53, my lord. My name has not been shown.
Ah.
See, I already filed Wakalat on 19/6/2020,
50?
53 and 53.1.
Ah.
In the place of Ramesh has given NOC Wakalat, I filed KP Bone Wakalat on 19/6 itself. I not brought file because I am not aware of that file.
Write your name on the paper and give to
Yes,
the
ma'am.
court.
Next week, any date. ma'am.
53 and 53.1 in place of Mr. Ramesha BM.
Yes,
It is submitted that Mr. So-and-so has filed the wakalat. The registry is directed to print his name.
next week, my lord.
Pose this matter on 9th,
Much.
Serial number 38,
30?
serial number 38.
Ah.
That matter be going to settle 2 weeks time may be granted in this matter. I am for the respondent. The trial court is negotiations going on. I got that morning information. Going to settle.
Go
this-
for the petitioner or the respondent?
Respondent.
IA 1/23 is filed by the advocate for petitioner. He has to be here. Let us see why he has filed an IA.
So
Yes.
For respond on 1
Lord, the coordinate bench of this honorable court, my lord, condoned the delay of 9 years, my lord. And he said, decision was, my lord, confirmed the division bench also, my lord.
Take that. What is a single judge judgment? Because in this, there is no ratio laid down.
No, my lord, I do agree, my lord. I do
No,
agree,
no.
my lord.
Give the learned single judge's order.
I have not found that order, my lord.
But this is not a judgment where a ratio is laid down.
I do agree, my lord. My only submission is, my lord. Today also I am making same submission, my lord. I am ready to go on with the day by day trial, my lord. If the court provide opportunity. I am not going on any merits and all, my lord. I don't want to argue on merits, my lord.
Because please understand, now someday you will also be this side
Yeah,
in
I
the
do
same
agree.
matter.
Yes.
Thing is, courts cannot come to the rescue of a litigant who is not vigilant. When something says of 90 days, you take 9 years or 8 years for
7
that.
years.
7 years.
And how can that be an excuse? And that kind of an excuse, if the court starts entertaining for on various reasons, there is no end to the litigation. That's not in the interest of the system, nor in the interest of the other party who is made to wait for years together for you to come and file the written statement. That's why there is a timeline. This court in all the cases giving a strict, an indication to the courts below not to do that. Now, if this court condones it, what a message the court would be sending?
In exceptional cases, my lord, this court can direct the trial court.
Please
for
tell the
time-
court-
time-
no, no, no.
1 minute, madam.
I can
Within-
understand.
within
No, no,
1
no.
month, madam.
No, please understand one point. There can't be any straitjacket formula. It all depends on the facts of the case.
Yes.
Please tell the court on any of the paper that is filed before the court that there is a genuine reason. Once you say that there is a genuine reason, we'll to do it, but not for the sake of asking. Please tell the court, one paper, one averment,
I don't want
one
to argue on merits,
sentence.
madam. I don't have case on the matter.
but then I'm sorry. Please come. Present Anita. Change this. Completely turn. Agreed with the order passed in. I number.
I number 12, my lord.
I number 12. Invoice number 274 of 2014. Whereby the court below had dismissed the application filed by the defendant. And
Fourth defendant.
Huh?
Fourth defendant. Defendant number 4 before the,
fourth defendant. Where is the order?
already in page number 28, Annexure E.
Had dismissed an application filed by the defendant number 4, seeking permission of the court to file written statement by condoning the delay. Then counsel appearing for the fourth defendant submits that the respondent herein has filed a suit for,
Suit for declaration, permanent injunction and cancellation of sale deed executed by
you were
the,
giving the dates the other day. Please tell the dates.
my lord, suit filed on 10/6/2014, my lord.
Suit filed on
10/6/2014.
10/6/2014 is the suit.
Please, my lord. The defendant appeared before the trial court on 11/8/2014.
1 minute. Defendant appeared on
11/8, the present petitioner hearing. 11/8/2014. My lord, the application filed before the trial court on 30/8/2021.
30/8/2021.
My lord, the application was dismissed.
Dismissed by order dated
My lord, order on 21/9/2021.
21/9/2021.
2021.
What did you write? The respondent herein filed a suit for declaration and injunction and for cancellation of
Cancellation of sale deed executed by the defendant number 1 in favor of the defendant number 2, defendant number 2 in favor of the defendant number 3, and defendant number 3 in favor of the defendant present petition.
seeking cancellation of the sale deeds executed by defendant number 1 in favor of defendant number 2, 2 in favor of 3, 3 in favor of
Present
4.
petitioner.
The suit was filed on 10/6/2014. In that, the defendant appeared, fourth defendant appeared before the court on 11/8/2014. Then he has filed the present application on 30/8/2021, seeking leave of the court to file the written statement that came to be dismissed by way of the impugned order. It is a case of the defendant before the court that after his appearance, he is attempting to search certain documents to file his written statement. He, after gets the records, took time. Now he has come up with his application, seeking permission to file written statement, submitting that he could not file the objections in time, and the delay caused from his side was inevitable, as he has misplaced the records pertaining to the suit scheduled property. As such, the delay is not intentional one. He has a good case on merits. As such, he may be permitted to file the written statement. The court has observed that the counsel has never argued at any point of time explaining the cause for the delay in filing the written statement. If that is the only ground, the same is not maintainable, and there is no option left for the court except to dismiss the suit. Itself is not maintainable. The court observed that the defendant has argued about the maintainability of the suit. The court observed that the counsel is representing a private party. He doesn't have a locus to argue on behalf of defendant number 5 to 9 as to their interest. And further, the counsel has made his appearance immediately on 11/8/2014 and relying on the judgment of the Honorable Apex Court in case of Zolba versus Keshav and others, the court had observed that if the fourth defendant is permitted to file a written statement and the same is taken on record, it will be the untold hardship caused to the plaintiff, which cannot be compensated in terms of imposing costs. The matter is in the conclusion stage. No, it cannot be reopened. It cannot be reopened, and accordingly dismiss the petition. Learned counsel appearing for the petitioner submits that as a petition, that as a defendant had a good case on merits, the same has to be yes, he has a good case on merits. The court below ought to have permitted the defendant to file the written statement. If he is permitted to file the written statement now, no prejudice would be caused to the plaintiff. But if the same is not allowed, he'll be put to a lot of inconvenience and a hardship, as the relief that is sought is for cancellation of the sale deed of the defendant, fourth defendant. He had relied on a judgment of this court, a division bench of this court, in Mohammed Anwar and others versus Sabir and others, reported in ILR 2004 Karnataka 2759. He submits that in this case, a learned single judge of the court had permitted the defendant to file a written statement after 9 years from the date of service of summons. When the trial court had rejected the same, the learned single judge has allowed the same, has allowed the said petition. Thereafter, this court has condoned the said delay of 9 days in filing and permitted the 9 years and permitted the defendant to file the written statement when the same has come up before the revision bench. It was the division bench has dismissed the said appeal that the order of the learned single judge does not suffer from any error or illegality. Basing on the said judgment, learned counsel submits that he will be going ahead with the trial on a day-to-day basis, and he may be permitted to file the written statement. Sound. Anybody? He may be permitted to file the written statement. The learned counsel appearing for the respondent plaintiff submits that when the suit was at in the year 2000.
No, 2014 only.
No. It was at the conclusion stage when was this order passed? In 2019. This order is passed in 2019. In the said order, the court has observed that the suit is at the conclusion stage, and at this stage, allowing the defendant to file the written statement, it causes lot of hardship for the plaintiff. It is submitted that it's a suit of 2014. Now the suit is instituted about 10 years back, and it would not be in the interest of the party, in the interest of the plaintiff. And the trial court had rightly balanced the interest, rightly considered the irreparable loss to be caused to the plaintiff, and rightly dismissed the petition. Next. Having heard the learned counsels on either side, peruse entire material on record. The undisputed facts in this case are that the suit is filed in the year 2014. The suit is filed in the year 2014. The defendant, number 4, who is a petitioner before this court, entered appearance on 11/8/2014. And the present application for seeking leave of the court to file the written statement is filed on 30/8/2021. Now, the only reason that is stated in support of the IA is that he could not file the said document, he could not file the written statement at an earliest point of time, as he was searching for the documents, and as he could not find the documents, and finally, after finding the documents, relevant documents, now he is filing the written statement. And it is a case of the defendant that no prejudice would be caused to the cost to the plaintiff. This argument, this court is not able to appreciate. When the CPC stipulates a particular time frame for filing the applications or filing whatever of the applications, filing a written statement or a time frame is prescribed for every act to be done. Normally, in that it has to be done. If for whatsoever reason, whatever is the delay, if something could not be done, there should be a reason for that. And if in the facts and circumstances of the case, if the court finds that such a reason is a genuine reason, and in the interest of the parties, that has to be condoned, and the party who has come before the court should be given an opportunity. The courts have to look at the interest of both the parties and balancing the same. The orders would be passed. Now, in this case, when he has filed a written statement after 7 years, without any plausible reason, the courts just like that, as a matter of right and as for a matter of asking, cannot permit a defendant to file a statement after 7 years from the date of the suit. And the judgment, the division bench judgment, which the learned counsel has relied on, do not lay down any ratio which is binding on this court. That order of the Honorable Division Bench refers to an order of the single judge condoning 9 years and which is confirmed by the Division Bench. That order, as there is no ratio, is not binding on this court. Binding on this court. In the considered opinion of this court, when a litigant who is not diligent in pursuing the matter and who has come up before the court without a valid reason cannot be permitted to contest the matter after 7 years by filing a written statement. In that view of the matter, this court finds no reasons to interfere, accordingly dismissed.
Petition counsel, may kindly pass over this. Petition counsel,
Yes,
kindly pass over this.
pass over. Yes. Keep the mic straight onto the right. What is the order impugned?
Interim order is passed in IA number 3, that is for maintenance order.
Where is that?
It is in annexure A, page number 26, Your Worships.
Page number 26. You are for the husband or wife?
Husband.
You're questioning the maintenance order.
This is passed without hearing us. We had filed the objections for IA.
Uh,
Though we had filed the objection on IA, it was taken on
Anyhow,
record.
this is of the year 2022 writ petition. Take notice on the council before the court below, then we will hear it. The petition is permitted to take out notice on the council appearing for the respondent. Same, when can you take out? When the matter to be listed?
Next, after 2 weeks.
Pose this matter on 23rd. A memo to that, a memo on the, shall be filed before this court by 18th. If the memo is filed, post this matter on 23rd.
Which
Yes.
is my lord? Lord, number one matter, first matter, my lord,
Uh.
where by virtue of the interim order, my lord, I deposited 15,000 before the trial court, my lord. May be permitted to withdraw, my lord.
That, give that file. Let's see the interim order. Dated, interim order dated,
My lord, 14/12/2022.
that's all. At the end of the order, this court on 14/12/2022 while granting on 14/12/2022 has directed the petitioner to deposit a sum of rupees 15,000 with 15,000 with the civil court as cost payable to the plaintiff, subject to further orders in this petition. The petition is permitted to withdraw the same.
Okay, for the petitioner notes, matter
Yes.
pertaining to the interim maintenance,
Huh.
the impugn order dated 19/9/2000.
Notice is served?
I filed
You have
vacating.
Yes.
I am for the husband, my lords,
Hmm.
petitioner. The impugn order passed for the trial court directing the petitioner to pay 20,000 per month, which is challenged in this writ petition
20,000 to the wife or a child also?
to the wife.
What is the income of the husband?
Husband, he is working at the plant, senior manager at Plant Tech Solutions, drawing salary of 1,41,000.
Hmm.
And meanwhile, she is also working as a senior project manager.
And how much she is earning?
She is earning around 66 to 70,000 per month.
Huh.
So on that basis, my lords will file the writ petition challenging the impugn order. The matter, there is a stay in this order, my lords, and they are filed in vacating stay. And apart from this, I'm paying 10,000 as a domestic violence. She has filed in criminal listener's appeal, which I'm paying 10,000, my lords.
So what should happen to this?
He is also working.
Now, she's working and she's earning 70,000. You're earning 1,41,000.
I have a elder father, mother, and brother to look after, my lords. Even if my lords see the equal status of the parties, my lords, the husband as well as wife, both are equally well educated and drawing a good salary. Now on that basis, my lords, I'm paying 10,000 domestic violence act. Apart from that, I have made a deposit of 1
Let
lakh.
us see the order.
Great, my lord. So page number 14, my lords, annexure. I'll take it to my lord's operating operation, for page number 29.
Petition. Yes. No, where is the order?
My lords, page number 14, my lords.
Page number
14, my lords.
49.
14, 1 4, my lords.
14.
Application was filed by the wife, my lords, under section 24 of
14 is on anticipatory bail. To enlarge the petitioner on anticipatory bail is order.
Maybe it is my objection.
objection.
Yes.
14 of writ petition, my lords.
Please read.
May I read, my lords?
Yes.
The learned counsel for the petitioner has filed an application number 2 of under section 20 of Hindu Marriage Act seeking interim maintenance of 50,000 per month to the petitioner from the respondent from the date of main petition till the pending disposal of and the 20,000 awards and litigation expenses. In support
Son is also there.
my lords,
Son is also there.
They are twins, my lords.
Huh?
Twins.
Huh.
Twins.
You're paying any separate maintenance to the kids?
No separate maintenance.
And then who will maintain them?
Apart from that, my lords, we have filed assets and liabilities. Both we have filed, my lords, in that.
No, just it's an admitted fact that wife is earning 70,000 according to you. We'll just take it like that. You're earning 1,40,000, and you have 2 twins. I mean, you have twins.
Yes.
Then who will maintain them?
That's apart from that, I have my father, mother, and brother.
No, you have children also, not apart. First, you have to maintain your children.
I think the salary which is drawing by the wife, my lords, is sufficient.
Quite reasonable. Nothing to look at it. 20,000 is a reasonable amount. Where she has to maintain the kids also. 2 kids. You have twins.
Out of one, my lordship suffering from nerve problem, your lordship. Nerve problem of hands and leg.
Yes.
My lords, one more submission.
Make your submissions.
Apart from that, when I made an deposit where she can withdraw the amount where I have deposited 1,20,000. Apart from the order which was passed in Domestic Violence Act, 10,000, I made an account where she can withdraw amount which has I have made 1,20,000 deposit. I've stated.
What is that? I didn't understand.
well, it's apart from the Domestic Violence Act,
Hmm.
where the trial court has ordered to pay 10,000 as monthly maintenance. I've made an account,
Where she can withdraw only 10,000 per month.
not 10,000, she can withdraw any, how much ever she can.
Kindly come, Lords, kindly come to page number 868,
60?
8 of petition.
Hmm.
That is what he's saying, Lordship, in
Okay, my lords,
point number 4. Lord.
point number 4, my lords.
Point number 4.
Yes.
I say, for what of sufficient source to meet the quantum of maintenance granted to the tune of 10,000 towards twin children was so far not to be complied with by me. However, the respondent has opened a recurring deposit account at Indian Postal Service, Mangalore, to the tune of 1,20,000 in the name of the petitioner. She can utilize the said amount towards interim maintenance to the children.
It's a matter of trial where, Lordship, whether it is deposited by him himself or the wife has to be.
I have deposited. my lords. I have deposited.
And he,
No, what do you, no, you say that you deposited 1,20,000.
Yeah.
So how much, like, again, you will be, whenever that 1,20,000 is withdrawn, again, you will deposit another 1,20,000.
No, that my lords,
There should be a basis for that, how much they are entitled. Don't deposit, take away that 1,20,000. Let us fix the amount.
and subsequently, there is an order by the trial court to pay 10,000 maintenance under Domestic Violence Act. I'm paying that.
no, he himself declares that he has not complied it.
No, on the merits of this matter, you're paying, the court has ordered 20,000.
20,000,
Please tell the court how is it bad.
my lords.
That one submission you made is that you have a brother and the parents to take care of. That is one.
And my lords,
And she is also educated.
Educated.
She's earning.
and my lords, as per my, I'll take it to my lords, to page number. '66 of the petition.
Yes. Yes.
Have filed my assets and liabilities stating that the expenses incurred by husband, I need 60,000 per month.
Hmm. You need
Have-
60,000 per month for your expenses
Expenses.
and wife's salary itself is 70,000. Hmm.
And my lords, apart from that, even though there was a quantum of maintenance get to the trial court, the equal status had been looked. Now, in case the wife is not working, then it would be sufficient ground to grant of directing 20,000 per month from husband to the wife. Now she's working well enough. There's sufficient source of income. She has only twin children to look after. I have father, mother, and my brother who are aged of 66 plus above ages.
Yes. Yes.
I just pass on this judgment, Lord.
Hmm?
Pass on this judgment.
What is that?
Judgment, Lordship, on.
Yes.
Let's on those grounds, my lords, now file the challenging the impugn order. Well, which is the only concern of the preposition also laid down by the Honorable Supreme Court in Rajni vs. Sneha, where equals the capacity of the parties has to look after my lords now. Both are well educated. She's earning good. Now, on those grounds, my lords, we filed this petition and the impugn order came to be stayed by this honorable court. Now they filed in vacating stay. I leave it to my lords. If you will.
We'll hear him.
Lordship, he himself declares in page number 68 that he has not paying Lordship the domestic violence, whatever the amount granted in the domestic violence. And Lordship, as per his own contentions, Lordship, he requires 6,000 per month. Lordship, wife is earning 66,000. And Lordship, she has to maintain Lordship 2 twins. Out of one Lordship who is Lordship suffering from one ailment of nerve problem. And subsequently,
Is it nervous problem?
nerve problem. She has declared in her this one Lordship.
Hmm.
Nerve problem.
Yes, sir.
And Lordship, she now lives in the Lordship in the parents' house. Lordship, she cannot Lordship leave Lord without paying them. Lordship, she herself requires and Lordship to the children. She requires around 50,000 and plus Lordship, she has taken 8 lakhs per 8 lakhs amount as for Lordship the marriage expenses loan. She has to pay that as well, Lordship. So, Lordship, 20,000 which has been granted by the trial court is Lordship, even if it's Lordship downwards, Lordship, it is no Lordship.
Yes, please come. Agree to the orders passed in I number 2 in MC number 587 of 2022, the file of so and so dated 19 September 2023. The husband is, the husband is before this court. The respondent herein has filed, who filed the MC?
My lord's wife.
Wife filed. The respondent herein filed MC 587 of 2022 seeking divorce. In that she has filed an IA number 2 seeking interim maintenance at rupees 50,000 per month and towards 20,000 towards the litigation expenses. It is a case of the wife that in view of the differences between the parties and as she has been subjected to cruelty, she has to come out of the house. And she's come out of the house. It is stated that the husband is working at Plantech Industrial Services Limited as senior manager project at Mangalore and is earning more than 2 lakhs per month. And he has fixed deposits in various banks and an apartment at Shakti Nagar. So, is also having the ancestral properties. It is her case that the husband has exhausted all the money belonging to her. She's getting a salary of 66,000.
Yes, ma'am. 66.
66,000, and she has 2 kids who are twins, and one is suffering with a neurological problem. At least she requires 50,000 per month. Now she's staying along with the parents, and it's a bonding duty of the husband to maintain the wife. And she sought maintenance of 50,000 and 20,000 towards the legal expenses. The respondent had filed his the husband has filed his objections, where he has denied the fact that he's earning 2 lakhs. According to him, he's earning an amount of rupees 1,41,000.
Net salary. Net
1,41,000 net salary. And it is his case that he has to take care of his mother, his brother, take care of his parents and his brother. It is a case of the husband that the wife is qualified and having extensive work experience, and she is employed. And as such, she is not entitled for any maintenance. The court below both the parties have filed their respective statement of assets and liabilities. Court has considered the same, and also the submissions on behalf of both the parties. And the court has recorded that in the DVC case filed by the wife, the court has passed an order directing the husband to pay 10,000 per month, and also recorded that one of the twins is suffering from a nerves problem. The wife is getting a salary of 71,691. The court had considered the judgment of the apex court in respect to how a maintenance, while granting maintenance, what are the parameters to be considered by the court. And considering the fact that the mother is staying in her parents' house and has to take care of the 2 children. Considering the salary of the husband, the court had granted an amount of rupees. No litigation expenses are granted.
No.
The court had granted only 20,000 per month as maintenance, but no litigation expenses were granted as pleaded by the wife. Agreed thereby, the husband is before this court. And counsel for the husband submits that the court, while granting maintenance, has failed to consider the subtle law, wherein when the wife is educated and she is able to maintain herself, she is not entitled for maintenance. The court also failed to consider the fact that he has to maintain his my parents and brother. Further, he requires 70,000, 60,000 per month for the expenses. And also, it is this case that he has opened an account where he deposited an amount of rupees 1,20,000, which the wife can withdraw for the maintenance of the children. He submits that when in the domestic violence case, an amount of rupees 10,000 is granted, and when he's paying, and again 20,000, which he cannot afford to pay. And also in the facts and circumstances, you do not require to pay considering the income of the wife. Next part. When counsel appearing for the respondent submits that, respondent wife submits that the husband is not paying the amount as granted under Domestic Violence Act. Further, considering the health condition and the maintenance of 2 kids, which is exclusively taken care of by the wife from when they were separated,
Your Lordship. Your Lordship.
when they were separated.
Separated, Your Lordship, from after birth of child, Your Lordship.
Huh?
After birth of child, children.
That she has been taken care from the separation, from the date of separation, as she has been taking care of the kids. Kids, the court had rightly considered all these aspects. And in fact, the amount that is granted by the court is on a lower side, as she requires minimum 50,000 to maintain herself and the kids. He submits that when the husband states that he requires 60,000 for his own expenses, but on a salary of 70,000, the 3 people have to live on that. And it is submitted that there are no grounds to interfere with the order passed by the court below. Next part. Having heard the counsels on either side, there is the material on record. The admitted facts in this case are the husband's salary and the wife's salary. The wife's salary is 1,71,000. What is that? 71,000?
So net salary is 1,73,000, gross salary. Wife is Your Lordship,
6,000.
net salary is 66,000.
Earlier, I said
number
the
81.
salary of the husband is so and so, and the salary of the wife is in the other paragraphs it is there, is so and so. The husband's salary is double the salary of the wife, and the wife is taking care of the 2 children. It is a submission of the counsel that he also has to take care of the parents and the brother. But at the same time, it is also the responsibility of the father to take care of the kids and the husband to take care of the wife. And just because the wife is earning and that she is not entitled for any maintenance, there cannot be such a proposition. In this case, the courts have to look at the social status, the income, and other relevant factors while fixing the compensation. Considering that the wife is taking care of 2 kids and one of them is suffering with some medical, suffering with a nervous problem. Court had rightly granted an amount of rupees 20,000, and this court do not find any reasons to interfere with the same. Accordingly, dismissed. Yes, next.
It's fine. Said that clearing the arrears, 10,000 rupees is still due. Couldn't muster enough money to pay it on the last hearing date. I have advised him to pay it at least by next year.
What is that?
10,000 rupees is still due.
Why? On 18/6, this
That's right.
matter.
I had submitted the other day that I will advise him to clear the entire arrears. Still he couldn't muster so the enough money. Even some reasonable time I have asked him to clear the task. 90,000 rupees he had to shell down immediately. Therefore, another 10,000 rupees he couldn't make arrangements.
What are the arrears now?
Now 10,000 rupees is the arrears.
Then we
Another
get it to the
5,000,
benefit then.
another 5,000 rupees, if it is added to this month's interim
No,
maintenance,
we'll pass orders on the merits of it.
it will be around 15,000 rupees.
What do you say?
Can be, but my learned friend said that he will speak to the client and settle the.
Madam
whole
gave a
thing.
proposal.
So when both of you want this matter to?
I have given the proposal, it is in his.
When do you want? When
I have spoken to him once. He said he will come back 2 or 3 weeks time maybe.
Suppose this, it is submitted that there is a likelihood of settlement between the parties. Pose this matter on 24th.
1 week later,
24th.
1 week later.
Huh?
1 week later, like 28 or
You want
30.
1 week late. If 1 week late, then 31st.
Very
31st.
Interim order to be extended.
Interim order earlier granted is extended till then.
For the petition. It's maintenance, interim maintenance awarded by Milords, the family.
How much is awarded?
10,000,
You are for the husband.
My
You're
husband.
questioning it.
please.
What is the husband's salary?
Milords, 10 to 15,000 Milords in my assets and liabilities I have stated.
What is his occupation?
Milords, he's working Milords as a agent Milords in a real estate office.
And you're not even, you get only 10,000.
Milords, I am working as an agent Milords in a real estate. I don't run Milords a real estate.
So if you want stay, how much you're going to pay?
Milords, any reasonable amount Milords that may be fixed by.
What is a reasonable amount according to you?
Milords, about 6,000 Milords.
Huh?
About 6,000 I can. Milords.
6,000. How many are the arrears? Arrears.
Milords,
When is
still-
that order?
Milords, order is passed on.
Date of order and
Please.
date of the petition.
Milords, order is passed on 19th of June 2023 Milords.
19th June 2023.
Please.
And you question that order in 2024.
Milords, some amount he has paid Milords in between. Milords, now Milords, he has no.
2023. When is the petition filed for maintenance?
Milords, 15th April 2024 Milords.
No. It is
Divorce
from the
petition.
date of
Please.
petition. When is that?
Please. Milords, on 5/9/2022 Milords.
5/9.
2022.
No, 22 months.
Please, subject to payment of various Milords.
That's
6,000.
what?
Please,
22.
please.
22 into 6. 1,32,000.
Please.
1,32,000 in 4 weeks.
6
And
weeks. 6 weeks.
everything concession. So, and continue to pay 6,000.
Please.
Please come. Agreed with the order passed in MC INM in IN number 3 and MC number 414 of 2022, whereby the code below 19th June 2023, whereby the code below are granted maintenance of an amount of rupees 10,000. The husband is before this court. Land counsel for the husband petitioner, husband submits that the income of his income is, as per his statement of assets and liabilities, is 10 to 15.
Please.
10 to 15,000, and the court has granted maintenance of 10,000, which is very difficult for the husband to pay. And the contentions that was raised on behalf of the husband were not considered by the court below, considering the submission of the land counsel for the petitioner. There shall be stay of all further proceedings pursuant to the so-and-so, on the condition that the petition shall continue to pay an amount of rupees 6,000 as maintenance by 5th of every succeeding month, and at 6,000 for 22 months, the arrears would come to 1,32,000. The same shall be deposited within 6 weeks from the date of receipt of the copy of the order. Either of this is not complied, the order granted by this court stands vacated without further reference to the court. Next, the petitioner shall take out notice on the counsel appearing before the court below and shall file a memo to that effect. On such deposit, in all these matters, on such deposit, the respondent is entitled to withdraw the amount. A memo shall be filed to the effect that the notice is served on the counsel for the respondent before the court below by 26th of June, 26th of July. Post this matter on 6 weeks means today's third. deposed on August 13th.
Arrears, if any, not deposit. Arrears, my lords, I am not very sure whether he has paid anything. But arrears, if any, my lords, he shall pay.
Arrears, if any, arrears. No, now thing is, it is, then you get it, why this ambiguity in the order, find out and inform the court.
Please, kindly pass.
Next.
For the
Yes.
petition by the aspirant, my lord, asserting
Yes.
the order granting interim maintenance of 20,000, my lord.
20,000.
20,000, my lord. The petitioner is working as a traffic controller in the KSRTC department, my lord. His take-home salary is 31,218. Gross salary is 43,000. Out of, after deducting, my lords, 31,218 is the salary.
Yes.
He has got aged parents, aged about 85 years, 90 years, my lords. And he is providing treatment to the parents. And he
Pay
is also.
10,000 as interim, pay 10,000.
Yes,
And when is the petition and what are the dates?
28/1/23 is the date of petition. From that as it has been ordered.
23.
23, January 23.
24, 12 months, plus this 7 months, 18 months. 18 into 10, 1,80,000.
10,000 has been already paid before
when?
Before the trial court. Before the trial court, 10,000 has been going on paying minutes.
You have deposited till now 10,000.
Yes, per month.
Well, record that contention. The learned counsel for the petitioner submits that the court below had granted maintenance of an amount of rupees 20,000 and the salary of the husband itself is 31,000. Then he has to take care of himself and the aged parents. And it is very difficult for the husband to pay the amount. It is submitted that the arrears also deposited at 10,000. Please assertively make a statement because I'll be recording it.
Well, kindly pass over. I will ascertain the trial court advocate.
Yes, next.
Item number 6, my lord. He has already paid, my lord, 50,000 rupees.
So far.
So far.
So if it is 50,000 rupees, how much the court said?
1,32,000.
1,32,000.
So 82,000, my lord.
He needs to pay. In the earlier order, the council submits that already till now he has deposited an amount of rupees 50,000. So from the arrears of 1,32,000, if 50,000 is deducted, it comes to 82,000. That he has to pay within 6 weeks.
Please. Great.
Yes.
That's item number A. I appear for the petitioner.
Yes.
My lords, in this petition, I am at the sympathetic jurisdiction of your lordships. My lords, my marriage with the respondent would take place, my lords, in the year 2012. I was pushed out, my lords, of the marital.
No,
court.
what is this?
The petition for directions. Petition for
Direction.
directions.
Which year is the MC?
2019, my lords, is a petition that was filed before the family court. My lords, 2000.
File the order sheets.
Very well.
Where is that?
My lords will find the order sheet, my lords, commencing from.
You have filed the MC.
I have filed the MC. My lords, brief facts, my lords, permit, I'll not take more than 2 minutes of my lord's time. My lords, 2012, my lords, my marriage would take place with the respondent. In my 2012. In my marriage, my lords, with the respondent, I have given birth to my lords a daughter who is presently in my custody. I have absolutely no employment at this point of time, my lords. I am staying with my parents, my lords, in a joint family. Ever since the day the respondent, my lords, would push me out of the marital home, which event would take place in the year 2018. Consequent thereto, my lords, in 2019, I am before the family court in a petition seeking the dissolution of my marriage with the respondent. 2020, my lords, 2019 itself, my lords would get the relevant page at page number 18. May I request my lords to graciously turn to page number 18.
Yes.
The order dated 13/12/2019. The respondent, my lords, would enter into his appearance in this case.
13/12/2019.
My lords would get that order at page
And you
number
have filed the MC in 18.
in 19.
19 only.
19. To be more specific, my lords, on 25th of October 2019.
25th October.
2019.
Immediately as
Immediately is entered into appearance. Now, my lords, what is the reason, my lords, which compels me to file this petition before your lordships, my lords? At this point of time, I've got absolutely no claims, my lords, against the respondent. All that I'm requesting the respondent is to have, my lords, resolution of my marriage, which was solemnized with him in the year 2012. My lords, I am deciding, my lords, with my parental family, My father, my lords, who has been recently diagnosed with a very, very serious illness, the medical reports which your lordships will get, along in the writ petition, my lords, at page number 100 of my petition. My father, my lords, who was on blood thinners, was recently advised to undergo a PET scan. And my lords, the report that have been arrived to after the PET scan are very, very disturbing.
Yes.
The stage before the family court, my lords, in a petition that was filed in 2019 until this day is only for the cross-examination of PW1. In fact, my lords, your lordships may record my statement. During the pendency of these proceedings before the family court, my lords, we made a submission before the learned judge of the family court that the matter may be referred to mediation. In all probability, if I set out my claims to say that I have got absolutely no monetary claims against you, I don't even want a single rupee from you. All that I want is the resolution of my marriage. And in the event you are desirous of taking care of the daughter, you are certainly free to do so. My lords, this mediation session, my lords, went on for almost 4 or 5 sessions. And ultimately, my lords, for some reason or the other, probably, my lords, in my understanding, for ego, my lords, that the respondent now wants to sword against the petitioner, my lords, the respondent would say, no, I am not ready for any settlement. I don't want to leave. Now, my lords, given the health condition of my parents, my lords, in particular my father and my age-old mother, my father, my lords, is desirous of settling my life in the event, my lords, I want to be successful in the petition which I have filed. So, my lords, I am before your lordship seeking for a direction to the family court for expedition.
What is the stage now?
For cross-examination of PW1. We are in 2024. Cross-examination of PW1.
Please come.
My lords would get, please.
The present writ petition is passing a mandamus to the direction to the court below to dispose of the writ petition and to dispose of the MC pending before the court.
Prayer your lordships will get at page number
Months
40.
from the date of the order. The present petition is filed by the wife who filed the MC before the court below. When counsel appearing for the petitioner wife submits that the MC is filed in the year 2019 and the same is pending from the last 5 years for the court below. It is submitted that you have not sought for interim maintenance also.
Applications are still pending consideration. An application is.
How can IA for interim maintenance be pending till now? Why it was not considered? Please point out that which court is this?
Well, this is the 6th additional court. Well, the DV proceedings.
Applications be kept pending for maintenance?
Well, insofar as these proceedings, the applications are pending. Parallelly, there was a DV proceeding that was filed. In the DV proceedings, my lords, we made a request to the learned magistrate to consider the.
When was your IA filed?
My lords, along with this application itself. In the year 2019 itself.
And an IA for interim maintenance filed in 2019, no orders were passed.
No orders were passed. Well, lords, I must concede before your lordships, we did not further press this application in view of the fact that the magistrate court, my lords, would grant me an order of maintenance. Thereafter, my lords, we did not press this application on a bona fide reason.
It is submitted that the right from 2018, the day she was necked out of the house, that's what you said?
Please, my lords.
The day she was thrown out
Very
of
well. In 2018, my lords,
when she was necked out of the
she was
house,
thrown out of the marital.
She has been staying with the parents. It is stated that the father is diagnosed with a serious health issue, and all the more reason that the said pending MC has to be disposed of at an early stage, at an early date. This court has perused the docket proceedings or order sheet of the court below. This is a MC of this is an MC of 2019. In fact, in a judgment, in an order passed by a coordinate bench of this court, where the matters were directed to be disposed of in a timeline. What is the judgment?
That is reported in 2023. This is, my lords, in the case of N. Raji versus C. Deepa.
Justice Krishna Dikshit's order.
Please. Reported in 2000.
Timeline is 1 year.
Please.
Wherein an order was passed in WP number
My lords, this is reported in 2023, volume 5, Karnataka Law Journal, page 551.
551. What is the name?
My lords, N. Raji versus C. Deepa.
And Rajiv versus Deepa. A timeline was framed wherein the courts were directed to dispose of the matrimonial matters within a year from the date of filing of the same. Even considering the workload the family courts are having, but the matters can't be kept pending for these many years, as this being an MC of 2019. 2019, the same needs to be disposed of at the earliest. Next para. This court is not proposing to issue notice to the respondent as early disposal of the cases is in the interest of both the parties. Yes, accordingly, the petition is disposed of, directing the so-and-so to dispose of the pending MC within a period of 3 months from the date of the receipt of the copy of the order.
I'm very grateful. 551.
Yes.
I appear for the petition in this matter, my lord. This is a similar kind of matter seeking a direction against the lower court for speedy.
When is the MC? Which year?
2022, my lord. It was filed in third,
So
November.
why 2022 should be in there should be a direction?
My lord, the parties are staying separately since 2020, my lord. 7/9/2020, they are staying separately. And the respondent wife is staying in United Kingdoms, my lord. She has, and in this family court also, she is not appearing. And only her advocates had filed a petition for transfer petition before the Honorable Apex Court, which is dismissed for the reason that she is
So
staying.
these are all the things which you have to agitate in a different petition. That can't be a ground. No, this court will not. No, there are MCs pending which are of 17, 18. Now the courts are saying that the High Court is saying you dispose of till 19 first. So why should a priority be given to a
But the
22 matter?
case is getting pending for a mediation, but no parties are interested in
No,
mediation.
for
The case
that,
is
you
not
move an
going
appropriate
forward, ma'am.
application before the court below, and the court is not passing any orders, then for that you can. But there can't be any order directing the court below to dispose of. Why should this priority be given for a matter of 2022?
My lord, at least this honorable court's judgment, which was passed by Honorable Justice Krishna Dikshit, within at
But
least a year.
you understand what is, a judgment is passed, practically what is happening. Courts are burdened with a lot of work, which is practically not possible for them to do it. Now, if prospectively is other thing, pending things, how they can do it? Now, we
At
have
least
to,
that
we have to
time
take
frame
it in
may
a
be
phased
given,
manner.
like, a 1 year time
No,
frame may
no,
be directed to
that
the
can't
honorable-
be, that can't be. We cannot, for a 2022 matter, there can't be a direction. The present petition is fine.
My lord, at
Madam,
least 1 year time frame may be granted
a
for
direction
this
to the-
period is
So because you have come to the High Court, the court cannot tell the court to give preference to your case.
not preference, my lord. At least the dates for which it is posted, the proceedings, if.
And
is
all
taking
these
place.
kind of orders framing a timeline also can't be granted like that. That's the judgment of the Supreme Court. Unless and until those are the exceptional cases.
My lord.
What is so exceptional about your case? Please tell the court.
My lord, the parties are in a toxic relationship. They are
All,
staying
all
separate.
in all the matrimonial,
Lives.
no, understand that in all the matrimonial disputes, this is what happens.
For restructuring of their lives, my lord, this are the wastage of their precious time, my lord. Only 1 year time frame, if it is granted, that will be
That would not be appropriate from this court to give you a out of the way order.
but still it is 1.5 years it is pending and no proceedings have taken place, my lord. It is just coming as a wait mediation report.
You have to understand what is happening. Don't look at only your case. What did you write? Court below to dispose of the pending MC of 2022. 2022 within a fixed time frame, preferably 6 months, as expeditiously as possible. Let a counsel appearing for the husband is a petitioner or
Husband
wife?
is a petition.
The husband submits that the parties are separated from in 2020.
2020.
And that this petition is filed in 2022. And because of this, the pending writ petition has an impact on their lives. And that has to be disposed of as expeditiously as possible. Next, this request of this argument of the learned counsel and the request of the petitioner cannot be considered for the reason that the courts have to take care of the matters which are pending, which are the old, which are pending from the 2019. Priority should be given to the oldest matters. And this court has already passed orders that till 2019, all the pending MCs have to be disposed of by the courts by middle of this year, by September of this year. Now, at this point of time, this court cannot pass an order directing a MC of 2022 should be given a preference. Hence, this court finds no reasons to pass any direction to the court below and accordingly dismissed. Yes, next.
For the petition, my lords. For the against the interim maintenance, my lords. The petitioner, my lord, is a police constable. My lord, whereas, my lord, the respondent, my lord, is a fashion designer earning 30,000 rupees. However, my lord, she has not disclosed in her affidavit of declaration that she is a graduate.
How much the constable is earning?
My lord, he is earning, my lord, according to the pay slip, my lord, 51,000 and take home salary, my lord, 25,420, which is recorded by the learned judge.
How much was granted now?
My lord, 15,000 has been granted, my lords.
Pay 10,000
Please,
pending application.
please.
And when is the application?
My lord, petition is of the year 2021, my lords.
21,
25/1/2021, my lord.
25/1,
1/2021.
2021.
Please, my lords. 41 months, my lords.
To 6 plus this is 7.
Please.
43 months.
My lord, June, my lords. To June, my lords.
July.
July 21, my lords. Of course, my lords.
So 46 months into 10. It comes to 4,60,000.
43 months.
43. 4,30,000.
30,000.
4,30,000 in 4 months, in 4 weeks.
My lord. 8 weeks, you lodge me make it, my lords.
Then we'll do
2
something like this.
Two
Now 4 weeks, pay 2
Please,
lakh, 2,15,000.
Please.
And another 4 weeks, another
Please.
2,50,000, 15,000. It is submitted with the learned counsel that the salary, take home salary of the petitioner is 25,000.
Please.
And the court has awarded the maintenance of 15,000.
15,000.
And he submits that it's very difficult for the husband to pay, considering the submission of sums. The petitioner shall continue to pay an amount of rupees 10,000. And the arrears comes to 43,000. That is 43,000, 43 into 10. It is 4,30,000. This arrears, the first, the 2,50,000 shall be paid within 4 weeks, and another 2,15,000 from another 4 weeks from there on. Either of the 2 installments or he continues to pay the 10,000 by 5th of every succeeding month. The stay granted by this court stands vacated without further reference to the court. Next, with regard to his notice, he shall take notice on the counsel appearing before the court below and shall file a memo to that effect by 26th of July. Post this matter on 4 weeks will come to post this matter on 6th of August.
Please.
Serial number 11, I appear for the respondent knowledge.
Yes.
There is a connected matter, wife also challenged.
It is not listed.
The deputy number
It's still in,
16491 of 24, my lords.
1 minute.
it's still in the FR number. They have not cleared the office objections. It's what
When was it filed?
what copy they gave me, my lord, they gave me the copy yesterday evening.
No.
It
Vanita,
still
what
shows
has happened? There was a
22/6,
narration yesterday.
22/6, they seem to have filed it, my lord.
Yes, my lords.
They filed it on 22/6.
Appearance is before before court for prints. What is this?
WPFR number 16491, my lords.
WP is ready to impose.
WPFR number 16491 of 24, my
Registered
lords.
Before the, what is this? The file is put up along with it. There's some notice there.
My lords, the WPFR number.
1 minute, please wait. Yes.
It appears there are some office objections they have to remove. Let them remove the office objections and let it be listed. In the meantime, let them not precipitate the matter is always my request.
What is your petition?
My petition is to seeking diminishing.
Oh. Because this roster is not with this court, that what they have filed.
Oh.
Who is having the roster with us? It is, it comes up before Justice Shyam Prasad.
It's only, they're seeking
On
enhancement.
GMFC matters, yes, my lords, we are seeking an enhancement.
Categorization is not GMFC. That's the petition filed by them.
No, we have sought for enhancement, my lords,
I think that's wrongly.
challenging the very same impugned order.
Then please look
Yes,
at
my
it.
lords.
You have not, then you're instead of
I will-
mentioning it as GMFC, you wrote something else. That's why it is not.
No, my lord, I will look into that, I will verify. I will look into that, my lords.
The land council for the respondents, the land council for the respondent submits that, like WP
The WPFR number
FR.
16491, my lords. No, no, no,
Why is it in
16491, my lord.
in FR number till now?
It's, I couldn't go. my lords.
No, without even.
I will
checking
look
the
into
office
that.
Objections, and you say that something is connected with the.
I think FR number has been wrongly taken, my lords. Senior counsel
No,
has
it is not a
addressed
petition,
it.
it's the FR number they have given.
No,
No, why should,
WP
now we
FR
hear your, no, we will hear his petition. No, if without complying with the office objections, if you say that something is connected, how is it right?
I
We
will
will
look
hear
into
his
that, my lords, when opportunity.
We'll
gives.
hear, we'll hear his petition on the merits of it. Yes, argue.
Kindly have it on next week, my lords. I will comply the office objection if any, and I will bring the matter
We'll
together
see
with this, my lords.
whether an interim order is required in this. If not, then we will adjourn. Yes. You're for the husband or the
I'm
wife?
for the husband, my lord.
What is the order you're
The
questioning?
order is paying maintenance of rupees 25,000 to the child and for payment of expenses of 35,000 rupees for the proceedings. My lord, I have only two submissions, my lord. Kindly come to the application filed
25,000 to the daughter.
to the daughter.
Uh,
My lord, the daughter, from the day my lord, the marriage took place in 2013.
mm,
The child was born on 12/7/2014.
12/7.
2014.
Mm,
My lord, in March 2017, she quits the marital home and she goes to her parents' house.
mm.
From that day till day, the child is not with me. I've never seen the child. I had made an application before the court in a writ petition. It was struck down. I have not seen the child till date. My lord, kindly
What
see.
is struck down?
Before the court below, I had made an application before the court
You filed a JNWC petition.
to seeking custody.
Uh,
In a writ petition that before the forum I had filed, that was struck down. Nevertheless, that's a different issue. My lord, now kindly see the application that is filed on page
No,
42.
you're not even exercising any visitation rights also.
Pardon me?
No visitation rights.
No visitation rights. I was
Right
granted that was struck down.
Right from 2014.
Right from 2017 onwards, I have not seen the child.
Now, what did you do when your petition is struck down?
Now I have filed it here in this before this court, that is pending. JNWC is pending.
When was it?
In 2019, from 2019 it's pending.
In that also you didn't see.
I sought for it is being stalled. Unfortunately, my client has never had the benefit of visitation rights, still pending. For some reason or the other, it's been stalled.
Stall means any stay order?
No, the proceedings are
Not
being,
proceeding further.
proceedings are not being going ahead. My lord,
Now, what is the income of the husband first?
my lord, I was doing hoarding business. The entire holding business in Bangalore city has come to a standstill. In my declaration of assets and liabilities, I have clearly stated that all my assets are frozen by the bank. I have no income. What the trial court would do is, in 2013, I had a turnover. That is taken into consideration and says you pay. Per contra, the respondent is substantially well off. She is very affluent. In her assets and liability statement, she does not disclose anything. The court notices that she closes both her bank accounts and she had about 78 lakhs in her bank account. Just after filing of this petition, she withdraws all those monies. The court notices that. Nevertheless, the court says you pay 25,000 rupees. Kindly see there at page annexure G is her affidavit of assets and liabilities.
No. Before that, let's see the finding of the court on this.
Yes, my lord. My lord, may come to from para 14, I will read, please, my lord. In the ink page 27. May I read, my lord? Parties to the petition have filed their respective affidavits in lieu of declaration of their assets and liabilities as per the guidelines issued by the Honorable Apex Court in Rajneesh versus Neha. On 8/4/2024, the petitioner filed application under so-and-so to register complaint against the respondent's jurisdiction match for offences punishable, stating that she has made a false statement in her declaration of assets and liabilities. In spite of giving sufficient opportunities to the respondent, she has not filed her objections to this application till date. On 17/7/2019, the petitioner filed IA number 9, directing the respondent to produce her bank statement of HDFC Bank, Virajpet from so-and-so. On 21/10/2019, the petitioner filed IA number 10, directing her to produce her income tax returns for the assessment year so-and-so and issue summons to the HDFC Bank, Virajpet branch to produce her bank statement for the period 4/4/2018 till 26/8/2000, particulars of fixed deposit. As per the order dated so-and-so, this court was pleased to reject IA number so-and-so. Agreed by the said order, the petitioner filed WP number so-and-so on the file of this court at Bangalore.
I think there was an earlier round of litigation on this. It came up
I
before
came
the
to this court, directed them to produce it. As per the order dated so-and-so, was disposed at directing the respondent to produce her income tax return bank statements 2 years prior to 26/8/2019. The order has also directed the petitioner that he shall cooperate with this court in deciding application. As per the income tax returns verification forms produced in this case for the assessment year so-and-so, the gross total income of the respondent was 4,18,000, 4,56,000, 6,72,000, 4,86,000, and so and so, respectively. The respondent has produced her statement of account maintained in HDFC Bank, Virajpet branch on 12/6/2018 and 26/8/2019, a sum of rupees 23 lakhs 9,410 and 20 lakhs 3,148 respectively were in the said account. And on 26/8/2019, she withdrew the entire amount of 20 lakhs 3,000 in this 148. In the said account statement, in the column of the summary, it is mentioned that the total debits and credits is 78 lakhs 32,537. Hence, it is clear after filing of this application, the respondent has withdrawn the entire amount in the said account for the reasons best to her, known to her. As per the statement of account, said account was opened on 4/4/2018 and closed on 26/8/2019. Hence, it is clear within a period of 1 year, 4 months, there was a total transaction of 78 lakhs 32,537 in the said account. At this stage, I am of opinion that this is a huge money transaction within a short period of 1 year and 4 months shows the financial condition of the respondent. Then comes my case. The petitioner has produced his income tax returns, acknowledgement of assessment years 2013-14 up to 2018-19. As per the said gross total income of the petitioner was 67 lakhs, 42 lakhs, 46 lakhs, etc. respectively. The petitioner has also produced copy of the petition filed by the respondent against her mother and brother in P&SC on the file of the Honorable District Judge Kodagu. In the said petition stated father died on so and so. The scheduled properties belong to her father, and on 6/5/2017, her father executed a registered will bequeathing the said properties to her and her mother. Scheduled properties of the said P&SC are comprised as land bearing survey number so and so, totally measuring 46 cents in one extent with RCC house and first floors at Virajpet town, and coffee estate in survey number 47/210 measuring 18 acres, along with valley property situated at so and so, so and so. In her affidavit of declaration assets liability, the respondent has stated she is residing in her parents' house situated at Virajpet town owned by her father. In the aforesaid affidavit dated 27/10/2021, the respondent has not mentioned anything about the aforesaid scheduled properties in P&SC zone. Therefore, my lord, she has suppressed her entire assets.
Why the court should come to her rescue?
Exactly, my lord. Why should the court come to her rescue, my lord? And my lord,
My lord.
We'll ask her. Yes.
May I, my lord?
Yes.
My lord, so this application for interim maintenance has been filed on 10/1/2018, my lords. And orders has been passed by the Honorable Trial Court while order dated 10/6/24, awarding interim maintenance of rupees 25,000 per month and litigation rupees of 35,000 only, rejecting any interim maintenance to the wife, my lords. As such, she has challenged that very same order in the WP earlier, what I have mentioned in the FR number, my lords, for enhancement of the money and also for the awarding interim maintenance to the wife also, my lords. And your lordship may have to see that since from the year of separation 2017 onwards, there is not even any maintenance has been filed by the given by the husband to the wife and child, my lords. Not even. They were applying all tactics, whatever possible, filing one or other with petition.
No, before that.
Yes, my lord.
When the court has observed that in several paragraphs, that
Yes,
the
my lord.
wife has come to court with a lot of suppression and misrepresentation of facts.
No,
Why
my
should
lords.
the- Why the action should not be initiated against the wife? Why the court has not taken that into consideration?
There is some mistake, my lords, in the observations of the Honorable Trial Court, my lords. The P&SC case which has been mentioned by the husband is that, my lords, and now
Not
that
the case,
there is a
not
will
the
left
case.
by the...
Not the case about not filing the assets and liabilities as per the law laid down by the apex court in Rajneesh versus Neha.
This
And
is with...
just before then that has reached to this court, then on the order passed by
Yes,
this
my
court,
lord.
you were directed, then you withdraw 78
We
lakh
produce, my
rupees.
lord.
You
No, my
withdraw
lord, that is...
78 lakh rupees and you say that you want maintenance.
No, that is not the individual account of the wife, my lords. She is having an age-old mother. Her father deceased in the year 2017 to help her mother to sort out the financial issues because mother is aged person. She is not in a position to handle her finances and all. Opened a joint account. It is that very particular account which details she has not given. For which only they have
get your case numbered, that your FR number, whatever that is pending. Then this will be
Yes,
heard
ma'am.
along with that, and till such time there will be stay. Please come. Agree
He is
with
seeking the stay on his own MC case, my
with
lords.
the order passed in I number 4 in MC number 1780 of 2017 dated 10th June 2024. The husband is before
And
the
moreover,
court. Yes.
no maintenance has been awarded to the wife. It is only to his own daughter. Since from the year 2018, nothing has been paid till today.
The counsel for the petitioner submits that the wife has come before the court with all suppression of facts, and she has not filed the correct statement before the court. Though the court has observed that the wife had failed to file the relevant documents and also the conduct of the wife, but still granted maintenance of 25,000. When a counsel appearing for the petitioner submits that the marriage has taken place in the year 2013, out of the wedlock, a girl was born on 12/7/2014. And in the month of March, in the month of March 2017, the wife along with the child has left the matrimonial home. From that day till now, he could not even visit the child. The earlier petition filed by him is dismissed. Now he has come up with a JNWC petition in the year 2019, and the same is pending consideration before the court. This next, learned counsel appearing for the respondent submits that the court below had failed to grant maintenance to the wife and they have questioned it by filing FR number
16491
16491.
16491 16491 of
24.
24.
16491 of 24. The land counsel for the respondent submits that the husband has not paid even a single pie to the mother, to the mother and the child till now. And till now, it is submitted that her petition that is filed by her for enhancement also has to be heard along with this. In response to that, land counsel for the petitioner submits that the court has considered only his income from 2013 to
2014 to 2016.
2018, I think. Income tax returns till
2018.
2013 to 2018. But as he was doing a holdings business, which has come to a standstill and is not in a position to pay the he is not in a position to pay the money to is dues to his EMIs to the bank in this regard. Considering the submissions of the petitioner and as the wife's petition is also pending, both the matters will be heard together and will be disposed of. Pending consideration of the same, it shall be stay of all further proceedings in MC number, NIA number.
That filed by the husband only, my lords, that MC petition. It is at
My lord,
the
may
stage of evidence.
No,
my lord may stay this order, that is sufficient. Ma'am.
The
Lord,
order
stay
dated
this
so and
order,
so
that
is
is
suspended. Impugned order is suspended. Post this matter along with the FR number so and so provided the office objections are complied with on 23rd. Yes. Next matter. On the earlier occasion, the number is given as writ petition, whereas it is FR number. Yes. Suspension of the order is.
For the petitioner, my lord, short accommodation. Short accommodation.
Why in a 2017 petition short accommodation? At the request of learned counsel, the petitioner posed this matter on 3/7/2024.
My lord, interim order may be extended. Please.
What I am saying and what is your submission? I said, on your request, it is already adjourned. You say interim order to be extended.
Sorry.
It can't be. Maximum passover, you please have to argue.
Okay.
It's a 2017 petition, it can't be adjourned.
I appear for the respondent. In fact, my learned friend who had appeared on the last occasion.
Yes,
he
that's
had
why
not-
passover, we'll hear it in the afternoon.
Very well.
Yes,
Very well. Great.
Yes.
yes.
There are two petitions.
I appeared for respondent.
Yes.
There are two petitions. One seeking dismissal of the execution petition, which may be taken later. The second writ petition may be taken, Lord. Which
58,119.
Yes, 58,119.
Arising out of?
Arising out of an order to arrest the judgment debtor in a suit for bare injunction, decree for bare injunction.
Bare injunction. Let's see that order straight away.
Yes.
Page number?
Lord, your lordships may come to page 54.
54. Suit is decreed when?
Suit is decreed in the year 2007. 2002, sorry.
2002. EP is filed when?
EP is filed in 2007.
Page number?
Page number 54 is the decree.
Yes.
Suit is decreed with cause. Suit is decreed with cause. Defendants, their men, agents, servants, or any other persons claiming through them are restrained from removing the fence. That is one. Trespassing into the suit scheduled property, or from encroaching of the same, or dispossessing the plaintiff from the scheduled property, or cause acts of waste and damage to the same, or in any way interfering with the peaceful position of
This
the
has
plaintiff.
attained finality as
This
no
is-
appeal is preferred.
I'll not contest that.
Now the where is the impute?
Now, Lord, for a moment, Lord, I just produce the decree copy because there is a slight variation in the number. It appears that after this decree, another number has been introduced by way of a sub-demarcation of the land. Now, this decree number schedule may be seen, Lord. Schedule is at, schedule is at the second page,
No, what is the number here now? Is it just know what you read?
126P.
54.
Yes, in the decree, number is 126P bar 807. In the decree, it is just 126P. I'll just take your lordship's.
No, in that original.
Decree, no?
There is
Original
no
decree.
decree here.
Yes,
Where is the decree?
the decree was not there. That's why on the last occasion I said, I'll get the decree. I've got the decree copy, type copy of the decree.
Even in the judgment, then let's see what is it mentioned.
In the judgment, in the preliminary portion of the judgment, they state. I have the handwritten decree copy also. Your lordships may see page 29. 29. Where they commence with the facts of the case. Plaintiff deposed in concurrence, 29 is the issue.
Survey number 126P.
P only. Now, not after they.
The Agrahara village.
Now when they put it into execution, kindly see page 57, the execution petition.
Page?
57, execution petition. Annexure C. They file it under order 21 rule 11, which is a provision for recovery of money in any case. The lordships may see the next page. Against whom to be executed, mode in which the assistance is sought, arrest of judgment data. And here they do not provide the schedule, perhaps because schedule is governed by the decree. But kindly see on the very same day, 15/6/2007, next page, they give the schedule, a different schedule.
Measuring 3 acres of coffees at
In 126B,
126P older.
new number 807. Reason is this, Lord. This 126B is a large government land. There were about eight or nine grantees there. None of them had gone to the government for demarcation of their lands. They were granted these lands in 84. This person has got the decree. Thereafter, he has gone for demarcation. Only 2 numbers were demarcated out of the 9 grantees. It was 806 and 807. He conceived that his portion was 807. Post decree, these proceedings have taken place. In the year 2000, subsequently, the revenue authorities have reported that this 807 is overlapping on my number. That is, I'll take your lordships through that.
No. When the suit is filed, when you file your
It was
written statement.
126P simpliciter. Because
So what is your stand in the written statement?
my stand in the written statement was that I own my property. Therefore, injunction cannot be granted. It was my stand.
What was the finding of the court?
The court in the OS, kindly see. Finding.
Para. The advocate for the defendant.
Yes, advocate for the defendant contends that defendant is in possession of total of 15.20 acres in survey number 126P of G. Agrara village, as he has purchased 7 acres of land. That is A written statement scheduled property from one Lakshmi Narayan and encroached 8.020 acres B and C written statement scheduled properties, which are in common block. He has fenced the said land / cultivated with coffee. Plaintiff and one of the defendants are instigated the Tahsildar to evict the plaintiff from the said land. He has filed suit in OS funds against the Tahsildar. This court has passed an order to maintain status quo. He has produced the certified copy of the order passed by this court in under Exhibit D1. This court has already disposed of the main suit, instead itself declining to issue interim injunction as prayed by the defendant. The defendant has pressed into service decision reported and not all that can be terminated. Then at the bottom, the advocate for the defendant country has
So you
approached.
can come to page 51.
50.
The defendant has also admitted that survey number 126 is not a pakka coded.
Yes, has not produced any order of the court.
51 from the top of 5 lines.
Top finance, yes. This defendant has also admitted survey number 126 is not pakka ported, which is not a revenue sub-demarcation of land or in part of the larger lands. At one stage, defendant contended that the plaintiff has not been pakka ported. It is highly impossible to identify the suit property without the correct boundary. As the survey number 126 is measuring 100 acres land, which is vast area. In another stretch, the defendant contended that he has purchased 7 acres from one Lakshmi Narayana, which is also in the said survey number 126 bar P measuring 7 acres. How he identifies the land without pakka porting? The defendant cannot blow hot and cold at one stretch. The defendant has furnished the boundaries to the written statement AB schedule properties, but the said boundaries are not depicting the sale deed, which has produced by the defendant under Exhibit 3. It creates doubt whether defendant is in possession of B and C schedule properties within the boundaries stated by the defendant. The plaintiff has not furnished the boundaries of the suit property within the boundaries furnished to the 7 acres land purchased by the defendant under sale deed dated Exhibit D3. Therefore, further forces the considered view that the plaintiff is in possession of the suit property. Hence, I answer the issue in the affirmative. Number one, this was so far as 126P was concerned. It so happened that in the execution, they inserted 807 for the first time.
Do you deny the fact that the subdivision has not taken place and
The subdivision has taken place post decree, perhaps, but
that has to be, then unless and until you mention that number,
yes.
when you say that
Your
it's no
lordships
such
are right. Your
subdivision.
lordships are right. But when we went to the revenue authorities, stating to them that there is a discrepancy in demarcation of 807, what they have done, Lord, is while demarcating 807 out of 126, they have superimposed it over my line.
No,
I raised
when,
this issue
when, no, no, one minute. When you have, when they have filed the execution petition, were there any objections from your side saying that this number is wrongly mentioned?
Yes, yes.
Where is that?
Yes, that was definitely stated. With the reports of the revenue authorities to that effect. Objection. Objection to the. No. But what happened was, after these applications were filed, revenue authorities surveyed the land. Because I raised an objection to the revenue authorities stating this 806 and 807 are overlapping my area. The revenue authorities have given a report that it is overlapping, therefore withdraw the podi, the pakka podi that was done. That your lordships will get, kindly similar, in the translation set that is provided. This is at the end of the petition,
Page
after
number?
page 103, the list of translations,
yes, it is
index
there.
of translation copies.
So we'll see your objections to that execution petition.
Objection. That is not furnished, my lord, but it is filed. It is filed or not filed? It is filed. I heard it is filed, it is not furnished. Do you have?
We'll ask him.
Copy? Yeah.
Was it filed? Not here.
My
But,
instruction is not filed containing that.
Now, when they say that, like this number, which has come up for the first time, they should have raised an objection in the year 2007 itself.
Yes, there is no objection. The entire reading of order also reflects that there is no such contention is raised before the court. Because my lords, kindly see page 96, my lords, as a reference.
Then what we do is we'll straight away go to the impugned order.
Please.
Yes.
So that what are your contentions
Yes.
advanced before the court?
Yes.
We'll be knowing from that.
Yes,
Please.
but actually, just before going to the interim order.
Yes.
I raised in evidence before this was filed in evidence. The revenue officer's communication regarding the pakka podi overlapping my portion, that 807, not 126. That objection was placed before the executing court and cross-examination was done on that basis. Kindly I'll just read that objection and the answer to the court to that objection. Court superficially runs through it. That's it. That what your lordships will get at 13, at page number 13 of the translations.
Yes.
13 to the translations. Translation copies equivalent. There are 3 communications of the department. Subject regarding to the, this is office of the Tahsildar, the Taluk in charge. Regarding the above subject to fix the boundary.
It starts from where?
This is
14 is. No, I'm looking at the translation.
Two copies are there. Why should I acquire?
Oh, it is double.
What is before me is dated 13/6/26.
Presentation. I'll just. But in the presentation form, dated 2/12/18.
2/12.
At the end. The Lordship has it, I think. And
No, I'm seeing the seats 13/6/26. Translation filed by you.
13/6.
Yes.
Ah.
He's saying that two sets are filed. What is before me is 13/6/24.
24. But can I just take your Lordships to the communication dated 27/9/16?
26.
27/9/16.
1 minute.
7/10/16. There are two communications.
Ask him to come. Something funny.
So you on there.
27/9/16. Yes, it is there.
Yes. And 2 pages later, 7/9/16. 7/10/16.
7/10/16.
I'll read 7/10/16 one. Just 2 pages later.
I find 27/9/16.
Yes, just
Date.
2 pages later.
After that, page
7/10/16. Yes.
Is 1/12/2016 is page number 16.
Then the next one, Lord. Next one. Very next one.
Where do you get the
7/10.
date?
Office of the Tahsildar.
7/10/2016.
Yes. I'll just read this because here they can arrive at a conclusive opinion. Regarding the above subject to fix the boundary to survey number 806 and 807. Yes.
EP is filed.
Yes.
In the year 2007.
7. Yes.
Now, this communication you're referring to is 7/10/2016.
16. What happened, Lord, was the authorities came, surveyed there, and that's when they reported the overlapping. And I'll just read that. Lord. By virtue of his application, survey work has been completed, subdivision has made as POD effected. That on 18/5/16, surveyor has gone to the spot and measured the land, shown the boundary. Further, at the time of survey, MT Bettegowda, as per their survey sketch said, belongs to them, and already survey sketch prepared much earlier. Further stated that the present revenue sketch 806 and 807 overlapped on their land, and it was intimated by the surveyor in their report. Thereafter, the applicant submitted an application to the Honorable Assistant Commissioner, sought for e-survey and fixed the boundary. As per the order 26/16 of Assistant Commissioner measured the land and shown the boundary of 806 and 807 to the applicant. Accordingly, sketch prepared and completed the measurement. At the time of survey, neighbor once again claimed said possession of cultivated land area belongs to him and earlier land survey sketch has been done. Copy of the earlier survey sketch given to surveyor as per the survey sketch said survey of 806 and 807 has been overlapped on their neighbor's land. That both the parties raised an objection. Hence, as per survey records, PT sheet and neighbor's revenue sketch enclosed herein and further action sending the file. The Tahsildar has reported, Lord, that as per the revenue surveyor's report, this 807 and 806 are overlapping into my land. And therefore, he said, conduct resurvey. It stood as that. Then they took suo motu action. Kindly similar to the Assistant Director of Land Records. Next 27/12/17. The above said subject matter, Mudigere Taluk, Gonibidu, Obli, G. Agrara village in survey number 126 granted to 9 persons. New number so and so, so and so. As per the body land identified the request of Manjunath Gowda, Sadan Gowda land in disputed lands as per grant PR number 126 so and so have been demarcated and hence called report of revenue inspector survey if there is any differences or in respect of granted land and body affected in the survey. Then, my lord, it goes to the Tahsildar. The Tahsildar, page 15, 10/9/16 communication. Shall I read that?
Page 21.
Page 20. 20. The next thing is regarding the identification of boundaries of 3 acres of land each in survey numbers 806, 807 for Manjunath Gowda, Sannu Gowda, so and so. This office letter, so and so. Not kindly, I'll just read that in connection with the above subject, it is observed.
Now, who is Manja Gowda?
Manjunath Gowda is the decree holder.
Is a decree holder.
He is a decree holder.
And Sadananda Gowda,
Sadananda Gowda is his neighbor.
that
Is
is,
it-
you are the, you are.
No, not me,
not the.
not me.
What it says, MN so-and-so and Sadananda Gowda does not have position of the approved land according to the report of the land survey.
Yes,
I'm reading at page 21.
yes, yes. That is the report. Actually, they do not have possession. Number two, to substantiate this, kindly see his application for arrest filed in 2007 and again filed in 2016. The revenue authorities are reporting that they are not in possession. Actually, he is using this decree in order to take possession. That is substantiated, my lord, at page 62. Kindly see page 62, my lord. Precisely, my lord, what has happened is he was not in possession.
What is the next communication at page 22?
Yes, yes. Thanks. After this, then the government of Karnataka, I think the Tahsildar, according to the letter from Tahsildar's Mudigere number so and so, the Tahsildar has directed Assistant Director of Land Records Mudigere to inspect the location. As per letter number so and so, surveyors and revenue inspectors visited the location 8 to 18. The surveyors have inspected the land in survey number 247 of Agrara village and newly rectified survey numbers 806 and 807. They have collected information regarding location and correct state of land. Surveyors have shown the boundaries of the land as per notice from 1 to 3 and 8. We have read and signed the statements below. That is what they stated. Yes. And in the Kannada version, Lord, the sketch is there where the overlapping is shown. That is at page number 89.
No, please come to the order. Actual order.
Yes, yes.
Page number.
Page number 101. This objection is addressed in a single line, not
Let's
considered.
let's see.
That page 100, para 80. Tel Aviv. Page 100, para 80. In the chief examination, para 18. In the chief examination, DW1 has stated DHR is not in possession of suit property. Honorable High Court of Karnataka has permitted them to file comprehensive suit to establish their right. It is seen that in pursuance of the same, JDRs have filed OS number 133 of 2000, which is dismissed. JDRs have further stated that on the basis of the report of the surveyor, the Tahsildar has written to AC and DHR is not in possession of scheduled property. But the question of possession of scheduled property by the DHR is already decided by the civil court of competent jurisdiction. We had actually said, Lord, we had not only said that they are not in possession, we had said that 806 is overlapping into my area as per the reports of the surveyor. That is not considered by the court below at all. Court just passes it over as per the reports of the revenue authorities. They had repeatedly said that 806 is overlapping into my land and therefore they are not in possession. Here, Lord, the distortion has arisen because original decree was over 126p and the execution number was 806, 807. That's why this distortion has arisen. And all these had been exhibited.
Now,
Yes,
now all these documents
yes.
you have relied on now,
Yes.
were they part of this?
Yes,
were
yeah,
they
that is
placed-
it. Para 11. Para 11.
Looking at page number 102,
102.
list of documents.
Yes. Yes, ma'am. Yeah, list of documents produced by judgment debtor, letter to AC Chikmagalur subdivision, copy of letter from Tahsildar, copy of requisition from surveyor, copy of letter to director ADL. All of them are
We'll ask him.
Yes, my lord. Just one more point, my lord. I'll just place before you. To substantiate, now, my lord, the revenue authorities reported that this 807 reoriented number was not in their possession. It was in my possession. It is overlapping. My lord, to substantiate this, what happened? When they filed the execution in 2007, they make an interesting statement in their affidavit evidence. I'll just take your lordships to that, which clearly indicates that they are not in possession. That your lordships will get immediately after the execution petition, but page 62. The last parameter, actually, I need not, 3 lines from the bottom. Thereafter, the JDRs have preferred appeal before the Honorable High Court of Karnataka, Bengaluru, which is also dismissed, appeal is dismissed. In spite of which, JDRs have violated the orders of the Honorable Court. Hence, I have filed the above petition against the JDRs for possession of the suit property, which is not the decree blood, and also seeking police help. Kindly see this blood. He says that he filed this execution petition for possession, which clearly goes to show that he is not in possession. And then, Lord, if your lordship recalls, he said that his fence had to be protected, that I am restrained from interfering with his fence. Actually, the property did not have fence at all. This reoriented 806. That is evident from the previous page. If your lordships were to see page 60. At page 60, top portion, 61. It is necessary to arrest and detain the GDRs in civil prison and permit me to fence the scheduled property with police.
No, then while reading this, we'll read the first part of it also. What is his complaint?
His complaint is,
Cause preferred an appeal.
yes. In spite of it, JDRs are trying to interfere.
No. According to him, you have damaged it. That's why he'll again put the fence.
But he never said that I have damaged the fence anywhere.
It's there at page 60.
Yes.
In spite of it, the JDRs are trying to interfere with the
possession.
And to cause damage to, and also
That portion is
act of
not there.
waste and damage to the fence of the same.
That portion is erased in my. Yes, then I stand corrected. So, my lord, actually, this is a petition in disguise of taking possession. They are seeking police protection and they are not in possession. They are trying to take possession. And that distinction between 126P and 807, which the revenue authorities have raised, is not addressed by them. And not under 61 of the Land Revenue Act, the revenue courts have jurisdiction over boundary marks. They decide the boundary marks. Therefore, he has to get over that, file an appeal or file a petition to get over that. And only then he can address.
What do you say?
Sorry.
Notes, in this case, after dismissal of a suit, decree of the suit, my lords, they went in first appeal, also in second appeal. In second appeal, if a title is issued, the my lords, liberty is given to them, my lords, to proceed with title suit. They filed a title suit. They failed in title suit.
What happened to the title suit?
Dismissed. My lords, in all proceedings initiated by me, all decrees in my favor, my lords, up to.
What is the title suit?
Title declaration they filed, my lords, in OS.
Declaration in respect of your property.
Declaration in respect of the property, my lords.
Your property.
Yes, my lords. That the suit has been dismissed. And my lords, now kindly consider, my lord, my friend is reading a part of a portion of affidavit, and my lords, it can be read as a typography because the second para of the affidavit of page 62. I am a DHR in the above petition. The execution petition filed by me may please be read as a part of this affidavit to avoid a repetition. I say that I am the owner in possession, occupation, and enjoyment of the petition scheduled property. Therefore, my lords, it's not that I'm seeking possession, my lords, is not correct, my lords. And now coming to my lords.
Before going into all these issues, no, there is a judgment and decree in your favor.
Please.
You say that this is your property and somebody is in violation of the orders passed by the court. He did something and you filed an execution petition. Now, this series of the surveys and all done, it gives altogether a different picture.
Well, there is no order
How
passed.
can it be executed?
There is no order passed. These are only communications what is placed before this court. Where, my lords, if my lords, an order comes.
They're part of the record before the court below.
Please,
Where is the consideration by the court below with regard to those?
Lords,
objections
court
that are-
consideration is this: when civil court declares in respect of my boundaries and my lords in survey number that I am in possession of property, my lords, where is looking into these aspects of the matter? These are subsequent documents which have come. And my lords, kindly, therefore, the
No, you also, now this is your property.
Please, madam.
Somebody is interfering. For that, identification of the property is required. Earlier in the decree, I mean, when you file the suit, the number that was given is some 126P or 126P.
Please, madam.
Now we say that it is 807.
Please.
No, because there is subdivision according to you.
Yes, madam.
So then that has to be confirmed by the survey department that there is a subdivision, and in the subdivision, this is a number you have got. For that, the interference or the report from the survey department is required. Now, when we look at the survey department's the report, where it supports your case, please show it.
Could I pursue, my lords? Page number 82, my translated copy is not with me. Letter dated 10/9/2016.
We'll look at that. I think that is at page 14.
10/9/2016.
You want to rely on 10/9?
Yes, ma'am. So, my lords, page number 21.
21.
Please, my lord. It starts at 20 and 21. The approval for the above 9 individuals is noted. Is got, my lord, says noted, but the map for approval of individual 9 number is not found. Only the revenue map of 8 individuals has been prepared. Later, the approval of Mr. M. N. Manjunath Gowda and MB
No, before that, can you please read the page 20?
Please, my lords. Regarding the identification of boundaries for 3 acres of land, each in survey number 806 and 807 of Manjunath Gowda, son of so-and-so, Moodgere Taluk. In connection with the above subject, it is observed that the Deputy Commissioner by order dated 39/84 has approved the following individual for coffee cultivation on a total 24
Even
acres
that
of
is your
land.
case that by virtue of that you are in possession.
Yes,
of
yes.
property. Yes.
My name is at serial number 5, my lords.
Serial number
5.
Sadananda.
No, my lords.
Manje
Manje.
Gowda. 5.
Please, ma'am.
Yes.
So far as my allotment is, my lords, is
Then please come to
accepted.
the next page.
Please, ma'am.
21, please read.
Please, my lord. The approval for the above 9 individuals is noted, but the map for approval of individual number 9 is not found. Only the revenue map for 8 individuals has been prepared. Later, the approval of Mr. M. N. Manjegoda and Manjunath Gowda and MB Sadashiv Gowda has been rectified and recorded as a new survey number 806 and 807. So far as 806 and 807, there is no dispute as to allotment of that number is concerned.
Then
Identification.
Then
the approval order has been issued for a total 9 individuals, but maps have been prepared only for 8 individuals. The reason for this is not clear. It is noted that Mr. M. N. Manjunath Gowda and MB Sadananda Gowda does not have possession of the approved land according to the report of the land survey. Therefore, if the approved individual do not have possession of land, does it not constitute a violation of the land approval condition?
what does it mean?
My lord, this is, my lords, it's the only communication I have not received to challenge this order. I have not received. These are the only, kindly, my lords, kindly peruse this annexures. There's no final order outcoming that conclusion arrived at saying that I'm not in possession.
So when the proceedings are pending before the court, executing court, when these kind of issues are raised with regard to execution of the decree, then necessarily when these documents are filed, the court should either it should say, no, these kind of documents cannot be considered. There is no force in it or something like that. No, without saying anything, there is a decree, it will be executed. That can't be.
My lords, this I'll come to that point.
Yes.
My lords, so far as the boundaries and my lords, a previous number, my lords, there is a finding of a civil court, my lord. Where, my lords, any dispute, my lords, if a revenue court cannot decide, my lords, ultimately a civil court has to decide that the boundaries and my
But
lords
unfortunately,
and
the
possessions is concerned.
subdivision had taken place after a judgment of a civil court.
Please, my lords, with boundaries, my lords. Decree has been with boundaries, my lords. Earlier number with the boundaries, my lords. And subsequently a number has changed, but boundaries have not changed.
At least you should have, what you should have done is,
Please.
now my survey number as per that is 126P. Now, by virtue of this subdivision, I fall in so and so, my land is here. Where did you say?
That is what observation by the trial court.
On basing on what?
That my lords, the evidence placed before the court, my lords. May kindly
What
find
is the evidence you place? Let us see. Please come to the order, page number.
Not
One not?
RTC, MR, my lords, sketch, my lords.
1 minute.
103, 102, 103.
Hmm.
101, my lords.
You exhibit P1 is a CC of order in RA.
Yes.
RTC
And
means
RTC, MR, Pahani my lord said.
of which year?
That the consent year, my lords.
What is MR? MR means?
Mutation record.
Mutation record.
By revenue
And that
authority.
is no dispute on that because according to you, you have been granted a land for no identification. is the
That
land.
identification number reflects, my lords, a change of number also in
Exhibit P5 is the sketch of which at the time of filing of the suit or after the subdivision.
my lords, so for that I'll examine.
That needs to be. Now, only one thing that is left. Please get instructions from your client.
Please.
Now, what this court is proposing to do is, we'll set aside this order and we'll remand the matter to consider it in the light of the subdivision. First, the surveyor should be appointed to, where is your land? After the subdivision, whether is it in 806 or not?
I'm in 806, my lords.
Who will say that?
That, my lords, that authority itself has said in this communication. That is what my lords in page
Unfortunately, he
20.
said something else also that you are not there.
No, but my lords, identification of survey number assigned to my properties 806 is admitted, my
Court
lords.
can as well direct it and get an authenticated thing saying that, then it can be executed.
My
Now,
lords, I'll convince my lord. Let my lords not make that mind, my lords. If I don't convince my lords, I'll leave it in my
Yes.
lord's hands.
No, one thing is, court is very clear on one point that the subdivision, when it has taken place, and as on that day, the survey number is something else.
Unless my
After
lords,
that
the
day-
boundaries are differed, my lords. Unless there is a boundaries are differed in
By virtue
subdivision.
of the subdivision, you should be able to say, after the subdivision, this is my property in so and so survey number, as per the record of the survey department.
Could I pursue, my lords, one para of my lords, a
Yes.
trial court? It
Yes.
page number 12, my lords, 96, my lord, para 12, my lords.
Yes.
During cross-examination of PW1, he has admitted that in execution, he has sought for a police help for fencing the property. He has stated that in chief examination affidavit, he did not seek for possession because he is in possession of it. He has stated that survey number 126/P
You're reading where?
has changed.
You're reading?
Para 12 of the minutes, page 96 minutes. Last two lines, my lords.
Yes.
He has stated that in chief affidavit, he did not seek for possession because he is in possession of it. He has stated that survey number 126/P has changed to survey number 247 and has again changed to survey number 807. He has admitted that JDR has filed RA 115 of 2006 against OS number 223 of 1997. He has further admitted that against RA 115 of 2006, the JDR has gone to the Honorable High Court of Karnataka. He has stated that he has not given any application for Hadbastu Sir. So far as my statement on 807 changing has not been disputed in the cross-examination. Therefore, my lords,
No, he has filed it, at least a paragraph on that by the court below.
Yes. That, my lords,
It should have been, that's how it should have been done by the court below. If there is a discussion on that, no, these are all the documents, that's fine. In fact, under the objections taken by them, by the judgment at with regard to, had it been a case that 126P is there, all these things would have not arisen because there is a judgment and decree of the court below, which has attained finality. The whole difficulty is about this 807. Unless and until there is something to show that after the subdivision, now, in the light of these documents, where there is some new doubts, the survey department.
it is not their case that 807 is not assigned to my property. It is not their case. They admit that the 807 is assigned to us. Therefore, the court finds that, my lords, a conclusion saying that JDR have further stated that on the basis of report of the surveyor, the Tahsildar has returned to AC and
the court should have, because already the survey department who are competent to deal or with all this, as per their reports, they have said something. The court should have called for the survey.
There is no order. That is only a communication between the authorities.
Court should have passed an order directing them to do something to clarify this. It should have,
My lords,
if had it been done, by this time you would
in
have got your.
execution proceedings, my lords, a court, my lords, cannot go beyond the decree. Therefore, my lords,
Beyond
that
the
is
decree,
also-
but however, when the executability of a decree comes into question, then the court has to do.
if there is a dispute as to, my lords, and 806 is not in existence. That 806 assigned to my property is not correct. If that is the case, my
Not
lord,
in dispute. When it is, you have to lead evidence before the court that it is not, it is subdivided into 807 and this is my number.
That is what the evidence has been laid.
That
my lords,
evidence
I'll-
is not your evidence. People who should say about it, when that is disputed. Now, if it continues for several years like this, you will not able to enjoy the fruits of the decree unless and until some, now from 17, this is pending here. So please get instructions from your client. We'll take it up tomorrow. Please, we should take it to a logical conclusion, not like.
Definitely, ma'am.
Yes. At the request of land council, the respondent pose this matter tomorrow.
My request day after tomorrow, my lords, he has to come from Udigere, my lords.
Monday then.
Monday.
Friday not possible.
Right,
Post
Tuesday,
on-
Tuesday, Monday, I'm not.
Tuesday.
Tuesday. Please. Please.
Your lordship, submitting memo for retirement. Your
Withdrawal.
lordship.
Take that.
Retirement, your lordship.
Retirement. Oh,
Yes, your
yesterday's
lordship.
matter.
Not yesterday, your lordship. It was.
See, let's see the docket. I think one matter yesterday I've posted it to today. That's what land counsel for the petitioner submits that he has already taken the petitioner has already taken the NOC and he'll come up with a memo on 3/7/2024. The No, you have to file something else along with it, not the memo like this. What is that? When did you give? What is that? All the particulars should contain. When did you give the NOC? When did he obtain? What has happened? All that you have to say.
Your lordship, we are not able to contact the petitioner.
Not the petitioner. You have given NOC. You should
Yes, your
tell it.
lordship.
When is it?
Give.
Just like that, you can't say that. Give the petitioner has filed a memo for retirement without disclosing all the details. You should come up with a proper memo. Yes. Pose this matter on 15th. Yes, next.
I sat for short accommodation 1 week, Milan. Last week itself, we filed a wakalat, Milan. Patel Karegoda.
Last week you asked for a
Yes,
adjournment.
Milan. We not received the papers, Milan. That is the
Who will give you the paper?
Milan. The party has not end out.
That is
Only the
between you.
wakalat has given.
It can't happen. Delete the name of Sri so and so and counsel appearing with the petition.
Yes, I agree, Milan.
You have asked for a adjournment.
Yes, Milan. I have not received the papers, Milan. Party has not come to the office, Milan.
2019
What?
family court petition. What will be there? What is impugned order?
Interim maintenance matter granted during pendency of the petition proceeding before the family court has been challenged.
How much is granted?
The matter has been disposed of only for the minor.
What will remain when if the main interim application is
Only interim, my lord, interim maintenance.
that can't be decided when it is. No, the final order might have been when it is passed.
Both have been passed on the same day. By the same judgment, not interim maintenance and final order has been passed.
How can it be? No, even now a final order is passed.
Yes,
Both of you agree. Now what remains in this interim order?
Up to disposal of the.
No, you will question it. How can it be questioned when it is that itself is disposed of? It can't be questioned.
Yes.
Please come. It is submitted that this writ petition is filed against an interim order, interim maintenance granted by the court below, and the final MC it's a maintenance case
Yes.
or an MC.
Yes.
That is a diverse petition has been allowed.
A diverse petition is allowed, and as the MC itself is disposed of, this writ petition has become infructuous, dismissed. Yes, next.
My lord, I appear for the petitioner, my lord. Lord, yesterday's matter, my lord, the 13D petition. Yes, ma'am. My lord, I am relying upon one particular judgment, my lord, of this honorable court, my lord.
Lord, Justice Isha Nanda.
No, my lord, it's Justice Abdul Nazir. My lord, this is, the facts are kind of similar, my lord. At page number 131, my lord, I request my lords to kindly take page number 131, my lord. My request my lords to kindly see the para number 2, my lord. It's arising out of a 13B petition, my lord. Both the petitioner and respondent at Family Court Davangere, my lord, had filed a 13B petition, my lord, which came to be decreed. The marriage was dissolved.
No, simple. The ratio laid down is a consent decree of divorce cannot be challenged by filing a suit. The remedy open to the respondent is to file an application in the same suit in which the compromise is recorded under Order 23, Rule 3A. Therefore, the court below ought to have so and so.
My lord, that is my submission, my lord. Here, my lord, I request my lords to kindly see this particular judgment, my lord. Subsequently, my lord, the respondent filed a suit, separate suit, seeking for a judgment for declaring that particular 13B petition's judgment as null and void. Then, my lord, the petitioner appeared before the court and filed a rejection of plaint application. That particular application came to be dismissed, my lord. While the arguments were commenced, my lord, I request my lords to kindly see in page number 132, my lord, it was submitted that already an application is moved before the Family Court, Davangere, for recalling the said judgment and decree. Even there, a recall application was moved, my lord.
This can't be the
My lord,
ratio.
my lord,
Legal position is very clear. You're unnecessarily laboring on something which is unproductive.
my lord,
Simple point, when a judgment, a compromise decree is passed, when you're questioning it, you should file an application before the very same court to set it. But what you did, you filed a petition under 151.
No, my lord, I filed an application under section 151.
That is not maintainable.
My lord, only the provision I have mentioned as section 151, my lord.
A scope of, it is not about a wrong provision. A scope of it under 151, under an application filed under Order 23, Rule 20, Order 23, Rule 3 years, it's completely different.
Please, my lord.
What did the court say? Come up with the application. You don't come up with an application and come before this court. For all this, for unnecessary litigation, I think this writ petition should be dismissed with exemplary cause.
My lord, the application, my lord, I request my lords to kindly consider.
You're not understanding by all this argument and by all this thing, you people are doing injustice to the client. Please come to the impugned order. What did the court do? Just court said, come with an application. Why did you not file it? It's a simple question.
My lord, the court below, my lord, asked us to file a miscellaneous petition, my lord. Miscellaneous petition before the same court under Order 23, Rule 3A. But my lord, I request my lords to kindly consider my application, recall application.
First, before that, you tell the court, why did you not do it? When it was such a simple, one typed application, why did you not do from 2018 and why the case is going around the court till 2024?
My lord, I request my lords to kindly.
Only for that you tell the answer. Why did you not file an application? What is the difficulty in filing the application?
It's because, my lord, miscellaneous petition would not arise, my lord. I have chosen a course of action challenging that particular judgment and decree itself. I have filed a recall application. The provision I mentioned is section 151. The trial court comes to a conclusion that since I have alleged a fraud, the inquiry has to be made. So what under section 10 of Family Courts Act, my lord, the Family Court can lay down its own procedure.
So you will do whatever you want to do and court will lay down its procedure.
No, my lord, I request my lords to kindly consider my recall application, my lord.
Why should it be considered?
My lord, I request my lords to kindly
petition is
see
not maintainable against that.
My lord, I had filed a MFA, my lord.
If a judge in MFA gives you a permission, it will not get you a right to file a writ petition, which is not maintainable.
My lord, in MFA, my lord, when I had challenged the judgment and
MFA is
decree
not
as well
maintainable. Writ petition is not maintainable. Your remedy is to go up before the same court. You go.
My lord, while the final order in MFA was passed, my lord, the Honorable Court has considered my submission regarding the recall application, my lord, where the court says that I have already adopted a course of action.
Please tell the court, can a court give you a liberty to file a petition? Now, if this court has no jurisdiction, you file a matter before a court in MFA, and MFA court says that you file a writ petition before this court, and now this court will assume jurisdiction to entertain the petition.
My lord, in the MFA, my lord, in that particular order, MFA order, my lord, the court comes to conclusion that I am also challenging recall application along with the judgment and decree that is passed in the 13B petition. So the court comes to conclusion that appeal is not maintained.
Now you have filed the writ petition.
Please, my lord, because
Now
my lord,
now I will pass an order that you have to go before the same court.
my lord, I may be permitted to convert that recall application to the miscellaneous petition at least, my lord.
You can do it. I'm not able to understand what is this big difficulty in converting and filing an application. Does it require any kind of effort? For that you have wasted, not you, not means you. Your client has, simply from 18 to 24 years before this court for no reason. It could have been done by the court long back. Things could have been resolved long back.
My lord, I still feel recall application can be considered because of the judgment, my lord, because only the provision of law I've mentioned.
For
in
that,
section
you will take
150.
6 years.
The different petition is not required as my submission, my lord.
No, that's what, for such a thing, you're going around the courts from the last 6 years.
My lord, they had not filed statement of objection. Only in the last week they have filed statement of objection.
Very unfortunate.
I have
state of
moved the
affairs.
matter, my lord. I have moved the matter.
Please go
in
before the
between
court.
also, my lord.
Whatever application that is required, please file it.
My lord, I may be permitted to convert that same recall application as miscellaneous petition, my lord.
Please come. You will file what the court wants you to file. No further direction. The present writ petition is filed, agreed by the order passed in an application filed by the petitioner under section 151 CPC to recall the judgment and decree dated 4/1/2009 on the ground that the fraud has been committed by the on the ground that the fraud has been committed by the other side. The present writ petition is filed. The MC is filed seeking divorce. Thereafter, the parties have filed a petition under section 13B of the Hindu Marriage Act for dissolution of marriage by mutual consent. The said matter was referred to mediation. And in the mediation, they have resolved their differences and settled all the issues, including alimony. Accordingly, memorandum of settlement came to be executed. Both the parties have signed the memorandum of settlement, which was recorded by the court on 4/1/2009. In terms of the settlement, the petition filed under section 13B of the Hindu Marriage Act came to be allowed, and the marriage of the petitioners 1 and 2 has been dissolved. And the marriage of the parties has been dissolved by granting decree of divorce. Accordingly, a decree has been passed. A decree was drawn on 7/1/2019. Now, an application is filed under 151 CRPC, wherein the petitioner wanted to recall the judgment and decree dated 4/1/2009 on the ground of fraud. Then the court has observed and under section 151 CRPC, the said order cannot be recalled. The party is at liberty to initiate separate proceedings, if so advised. Then questioning the same, the petitioner had filed MFA number 5637 of 2019. And this court and the division bench of this court by order dated 23rd September 2019 has dismissed the appeal as not maintainable, rejecting the application filed as not maintainable, that he can't file an appeal before the court seeking recall of the original decree of divorce by mutual consent, since the appellant has chosen a particular course of action and it cannot be considered. Now, after that, the present writ petition is filed. Learned counsel for the petitioner submits that the court ought to have considered the application. The family court has its own procedure, and as such, though an application is for only the provision of law is quoted wrong, as 151. The court ought to have considered it as an application filed under Order 23, Rule 3A, and ought to have considered the same. This court has perused the material. Then counsel for the respondent submits that the court had dismissed has held that under 151 such an application is not maintainable. This court, having heard the counsels on either side, peruse the material on record. Unfortunately, in this case, just for a simple application to be filed right from 2019 till 2024, one after the other, the petitions are filed and the matter is kept pending before this court. When the court has categorically stated that when a serious allegations are raised with regard to fraud and other issues, which are serious in nature and which requires a full-fledged trial, and ask the party to come up with an appropriate application. On that ground, now when MFA is filed and a writ petition is filed, this court is not able to understand what is the difficulty of the party to file an appropriate petition before the court. The contention that the family court can draw its own procedure doesn't mean that it should go by to all the procedures known to law. In the considered opinion of the court below had rightly passed the order, and this court finds no reasons to interfere. Accordingly, dismissed.
I appear for petitioner in this case.
Yes.
The petitioner has challenged the order passed by the first appellate court, reversing the order of injunction granted by the trial court. The petitioner's father was granted.
You are the plaintiff in the suit.
Plaintiff.
What is the suit for?
Suit was for permanent injunction.
Please come to the order in the suit. Injunction granted.
Injunction granted.
These are all in Kannada.
It is in Kannada. But I will tell my lord what has happened.
You can't tell because unless and until the court reads it, poses matter on 29th of July at the request of non-counsel petitioner. Yes.
My lord, now my lord, what happened? The already trial has my lord commenced, my lord. This case is my lord is held up.
At least you should have you know that the court can't understand Kannada. You should have filed a translated copy. If you are ready to file a translated copy, we'll hear it next week. Because without that, it is not something that basing on what you say, the court has to understand. Court has to go through the order and what it is said. If you can file a translated copy, it would be next week. Or else you won't get you don't have to file a translated copy. That's why I posted it on 29th.
Please.
Yes.
My lord, yesterday's matter.
Huh?
First petition is from the wife.
Pass over the matter for 230 minutes. Kindly pass. 230.
Yes, next.
Petitioner, kindly pass to order 230.
Pass over.
Petitioner, madam. My lord.
What is the impugned order?
Impugned order 6 through 70 amendment application filed by this petitioner was rejected, my lord.
Will pass over. We'll pass orders in the afternoon.
Yes.
Or else tomorrow, we'll record his absence and post tomorrow so that if he's not there also, we'll pass orders.
Yes, that.
When counsel for the petition is present, no representation for the respondent. Post this matter tomorrow. Yes. Yes. Where are they?
They were there, Lordship, I've seen them.
Pass over. 23.
Seek passover, Lord. Senior counsel been engaged. He has sought for passover.
All your passovers now on the list. Yes, 24.
My lord, my IA is not put up, my lord. Last time I filed an IA.
What is the IA?
IA for interim order, my lord, for educational
All
expenses.
for that IA? In this, I think they filed an IA. Give the details to the court officer.
Yes, ma'am.
No, 23.
So I was asked to
23,
file
I
it in the
think.
office, my lord.
In 23, I think.
Yes, my lord.
Yes, 24.
You're for respondent in this case.
You're for respondent.
Yes.
What is this petition impugned order?
In order, the petitioner filed application under section 151 of CPC seeking delivery warrant.
Hmm.
Here what happened is,
We'll have it. Any urgency for you? Any interim order is there?
nothing is.
No representation for the petitioner. Post for counsel for the respondent is present. Post for dismissal on 16th. Yes, next.
For the petitioner.
Yes. Who appears for the respondent? Yes, what has happened in our case? That Passover matter give, that party in person. 1 minute, Mr. Counsel.
Your Lordship, we went through the expenses, what she has given. The calculations are completely wrong. In the 2020-21 and 2018-19, the fee she has mentioned, as per the receipt she has given, it is 1,15,000. But here she is showing it as 1,75,000, 50,000 added more. Again, 2024-25, which now the respondent paid the first installment, that also has not been deducted in this, and she has added that too. So
just forget about, like, according to you, no, as per this, from 20.
The
No,
Your
no,
Lordship,
1
the
minute.
application is allowed on 2020.
No, we will deduct it later. From 2014 till 2023, you have paid 2024.
24 first installment.
You have paid. So
Yes.
from 2014 to 2023, how much are the educational expenses?
Almost, Your Lordship, after deducting whatever, almost 12 lakhs
You
to
did
12
your
and a half.
calculation.
12 to 12 and a half lakhs.
12 to 12.5 lakhs. Now, when is he going to pay that?
Your Lordship, so from 2014 till 2021, she was working. If the Honorable Court wants him to pay, he will have to pay it. She was working, she was earning 2,52,000 per month. He was working, she had deserted. 2021, we filed the divorce petition. 23 March 3rd, 23, she has filed an application under HMA 24 of Hindu Marriage Act. The application was allowed on in 24. So as per the family court order, we are supposed to pay the fees for 22-23 and 23-24. 23-24 and 24-25 for 2 years.
When was the application filed?
It was filed on March 3rd, 2023.
March 3rd?
2023.
2023.
Yes, Your Lordship. So the court has allowed that he bears the education expenses, medical expenses, and all other expenses from March 3rd, 23 till now, up to date.
So what is the yearly school fees for 2023?
It is 125 what she's
per annum.
132 in 24-25 she is given, and 1,20,000 in 23-24.
So 1,20,000 is that.
If we add the book set, uniform, and whatever she's asking for, Your Lordship, it's 1,58,689 plus 1,44,760.
What is that?
She has given school bag, water bottle, tiffin, accessories of. She has not provided the bills.
Anyhow, 1,20,000 is a school fees.
Yes.
30,000 is miscellaneous.
Yes, Your Lordship.
Huh?
Yes, Your Lordship.
It comes to 1,50,000.
1,44,760 of 23-24 and 24-25 of 1,58,000.
That you have paid already.
We have paid 2 lakhs as Honorable Court had ordered before the vacations, plus 45,000 of the first installment fees we have already paid. So almost 2,50,000 he has paid, Your Lordship, in these 3 months.
So as far as the school fees is concerned, it's 1,44,768. Then what about
Not only school fees, Your Lordship, everything.
Then what about the order of the court with regard to the maintenance?
Maintenance is ordered from the year March 3rd, 23
till up to date. So it is 2 years, Your Lordship.
March 3rd, 23.
Yes.
So
Date of application filed by her.
Is March 3rd,
23.
2023.
2023.
2023.
Yes, Your Lordship.
So 2023, 24 is 1 year. And another how many months? April, May,
The
June,
new year has
July.
started. Academic
4.
new year has started.
That is
First
12 plus
installment.
4, 16 months.
Yes.
How much was the maintenance awarded by the court?
There is no amount, Your Lordship. The court has ordered medical expenses, other expenses, and education expenses for the child to be borne. Because the reason was that she did not either give all her payslips, ITRs as per the Neha Rajni's judgment. None of the documents were provided in the lower court. So the court came up with a calculation that for the child, the father has to bear all the educational, medical,
And what
other
about
expenses.
maintenance to the boy?
That Your Lordship has to fix now, Your Lordship. There is no amount fixed by the lower court.
Hmm.
Now he undertakes to pay what I had discussed
And what about
last.
the medical expenses?
Yes, Your Lordship. Medical expenses, he doesn't have any other medical ailment unless he's wearing a glasses. Whatever it is, we are ready to bear, Your Lordship. If the bills can be given, we can provide the medical also, the education also, and other expenses. If the court feels fit that want to fix a monthly maintenance, we are okay. He's ready to bear education expenses fully plus 20,000 every month, which I told him that Honorable Court said it is very less. So he said, I'm okay to bear 25,000 per month and education expenses, which comes to almost monthly 12,000, which comes to around 37,000 per month.
So you have filed the petition for maintenance in the year 2023.
2022,
So-
September 20th, 2022 was the application filed for interim maintenance. Again, my advocate at that
No,
point.
she says 2023.
Application
Yeah,
date is
so
there.
application was dated September 22nd, but the injunction, it was not supported by an affidavit. So that was again submitted in the month of March 2023. That is what we did.
So that's March. So now according to you, no maintenance is granted to you.
Correct.
And even to the boy also, except that medical and school expenses.
Correct.
Other expenses or other maintenance is not granted.
Correct.
Now, according to the court, you have not filed all the relevant documents, which are according to the court. All the relevant documents which are supposed to be filed, you have not filed. Now, if we take the court order with regard to the medical and educational expenses, as far as 2024 is concerned, he has already paid. Now 2023, that 1,58,000 towards educational expenses, he has to pay. Then if it comes to medical, what are the medical expenses incurred by you for the 2 years, according to you?
Yeah, Lordship, I will come to that, but in school fees as well, as all of us know, that school is not restricted only to school fee. There are bags, uniform, different kind of activities that happen in a school.
Have you given the,
Yes,
have you
it
given
has been
bills and the
given.
breakup for that?
Absolutely,
Your
it
Lordship,
has
I
been
have added
given.
and told you that figure.
She added that, that's why she made it to 1,58,000.
No, that apart from that, extracurricular excursion day out was not included as per what they have mentioned. It was only the transport, the book set, the uniform and school bag and accessories were included in this. Rest of it is not included, which if inclusive will become 1,87,689. And for last year, it is already 1,67,260, which has been spent. So it is not being considered right now. And as per the bills also, I'm holding the bills right now with me. And definitely medical expenses are something that cannot be foregone with pandemic, post-pandemic as well. It has increased for, and child are susceptible to, and his immunity low is which was very low, and he's very susceptible to cold cough, which is very common nowadays. So for all the medical expenses which are listed here, and it can be seen, even one spectacle cost me 10,000 rupees. And every 6 months, you have to change the spectacle.
Yeah, you don't have to say all that. They're ready to
Ma'am,
pay.
I am telling this because it is being highlighted.
They will give it.
And he
They'll
is
give it,
finding, the respondent is finding all means and ways not to take the accountability of the child, which he has been doing from past 12 years, which is not acceptable. And that is why I'm standing in front of the court to ask and seek justice. From past 1 month, we have been lurring around the same document, not taking action on it because he is not ready to take. When I am already having the expenses from 10 years I have spent, I've not looked at it. Yes, I have done that. But now he is not ready to take. And this is what has happened in the past as well. where he has denied all his responsibilities. He's faking all the information that he is providing right now. I have proof for that. If you want, I can show you right now. The accommodation that he's staying, he's not staying there. I have the court records as well. I have sent it from here. The affidavit which was filed on 24th April gives that address. I have sent that this court document to that address. It is written here. He has left that location long back. And he's falsifying blatantly on affidavit that he is staying there so that he can escape all the expenses that he should.
What is the scope of this petition? Please tell the court.
To provide maintenance for the child and myself, which has not been awarded by the lower court. And I am being deprived for that from past 12 years.
You have to advance arguments on that. When the court is
Absolutely.
asking you, you have to specifically tell the court what the court has. If
Absolutely.
something beyond that is required, court will know.
Okay.
Now you told the court what are the medical expenses and
Correct.
what are the educational expenses.
Yes.
Now, as per the order, they will pay that. And as far as your maintenance is concerned, whatever as per the requirement, in the meantime, along with this expenses, you pay 30,000 pending consideration further orders by the court below to the boy.
Yes, sir.
To the boy. And her maintenance, let her come up with all the documents and with all the whatever that has to take place. And I'll direct the court below to decide this application within 2 months from the date of receipt of the copy of the order.
Yes, Your Lordship. Application has already been decided. If you can, if you are saying that he has to pay 30,000 per month from now onwards, he will pay it, Your Lordship. He will have.
Lordship, I would request that's a very lower amount. In the current situation, it is very low. Please understand.
Yes.
Kindly look into it.
Yes, please come. Agreed with the order passed in I number 6 and MC number 6189 of 2021. Whereby the court below had granted had directed the husband to pay only the educational and medical expenses and other expenses of the child, and not granted any maintenance to the wife. The wife is before this court. It is the case of the wife that MC number 6189 of 2021 is filed by
respondent in this
husband.
Husband.
Has filed with the husband seeking divorce. In that she has filed IA number 6 seeking interim maintenance at interim maintenance on date.
It is 21st
March
November.
23rd.
March
3rd March 2020.
3rd March 2023, wherein she has sought for a maintenance of an amount of rupees 2 lakh per month for herself and her minor son, aged 10 years, and 50,000 towards litigation expenses. It is a case of the wife that the husband is currently drawing a salary of 3,50,000 per month.
Lordship, I request you, that's not the current amount.
It is 2 lakh.
That's not the correct amount. It's a falsified amount. And the court below has already acknowledged
I am
this.
looking at from the order. How can
Absolutely.
they have to record it as per the court order?
Absolutely, Lordship, that's what
That
it
is
has
what
been.
you have said.
No, that is what was told to us earlier. But when the court has on the impugned order itself, you can kindly refer to it. It is 5,67,000.
Then I will record that also.
Yes,
I'm
please.
recording it from the order.
Yes. And I'm still not given the documents, the sets of affidavit of.
You know what is
SSL
the difficulty to deal with the party in person? This is a difficulty because you can't understand. Court is being very accommodative to you.
I understand.
Heard you so many times. And also asked him to give you an interim relief. You have to understand because court always wants to do justice to you. It is all out of your anxiety or feeling that something is not happening. No, there is order still to be dictated. End of it, if you feel something is not, you can tell the court. And as general manager and is drawing salary of 3,50,000 per month without any reason, he has neglected and failed to maintain the wife and the child. And it is becoming very difficult for her to meet the expenses of herself and the child. Hence, the present application is filed. The objections are filed by the respondent husband. It is stated that he shifted his residence to Whitefield for the convenience and comfort of the wife, as her office was located at Whitefield at the time, and he was traveling to Yeshwantpura to reach his office. And he has stated several things with regard to the disputes between the parties, and stated that even though respondent is working even after separated from him, she's claiming maintenance from him without giving access to the child. The wife had deserted him in April 2014 along with the child, and she's working with Mrs. High Peak Software Bangalore till 2021. She resigned her job when he filed this petition. Even at the time of filing the petition, she was working, and she resigned her job with malicious intention of claiming maintenance from him. It is stated that he is not in a position to pay 2 lakh per month as maintenance since he is having liabilities, but he is ready to meet the education expenses of the child and upbringing, provided that he is given the child's visitation. The court below, after considering the parties have filed their statement of assets and liabilities before the court, wherein in the said statement of assets and liabilities, she declared her education qualification as BE within brackets IT and PG DBM. It is stated that she requires 2 lakh per month, and she is in need of rupees 30,000 towards household expenses, rent 3,000, towards maid servant salary 2,000, towards medical expenses 5,000, towards conveyance 5,000 towards conveyance. She also claimed that she is in need of 4 lakhs per annum towards food, clothing, and medical expenses, 1,50,000 to 1,70,000 towards education and other expenses of the child, 1 lakh towards other miscellaneous expenses, as she is unemployed and she has no independent source of income. According to the respondent husband, the wife had filed her bank statement maintained in Standard Chartered Bank from 1/1/2022 to 29/1/2022, 1/2/2022 to 28/2/2022, 1/3/2022 to 31/3/2022. The entries in the bank statement shows deposit of 95,022 by Highfix Software Private Limited. The respondent produced a bank statement from 1/4/2022 to 36/2022. The entries in the bank statement support the case of the petitioner that the respondent was working. The court observes that it supports the case of the husband that the wife is working for Mrs. High Peak Software. The bank statement produced by the wife with memo dated 3/6/2023 reflects that it is a collection of breakup bank statement, and the respondent conveniently avoided from producing the bank statement of the end of the month from January to February, etc. The court has considered, looking at the bank statement, the court comes to the conclusion that she works with High Peak Software Limited, and she was earning more than 2 lakh per month, and which shows that the respondent is capable of maintaining herself, and she was earning even as on the date of filing the petition and subsequently. The husband has also, the husband has also produced his affidavit of assets and liabilities, which shows for the assessment year 2023 to 24, his income was rupees 67,52,661, means how much per month?
2,93,000 in
How
hand.
can it be?
They deduct everything, no, your lordship. PF, everything is deducted only after that, after tax deduction, after PF, after all other deductions, it comes to around 2,92,000 in hand to her.
No, a salary, no, if it is, if it has to be at least 5 lakh per month, it would come to 60 lakhs. Now, for example, 5 lakh salary after PF would become 2.5.
30% tax is deducted, your lordship. Out of that, directly 30% tax is deducted. That's in-hand salary and what his salary is on paper.
The document produced before the court observed that the document produced before the court reflects financial ability of the husband and his standard of living, and held that the husband shall pay the entire educational, medical expenses and other expenses of the child. When this matter came up on on 25/4/2024, this court had directed the father to deposit an amount of rupees 2 lakhs to the account of the wife by 10/5/2024, and directed and permitted the father to visit the child on Saturday between 11 a.m. to 1 p.m. and on Sunday between 4 p.m. to 7 p.m. and also directed the party in person wife to produce all the expenses. Where it is submitted before the court that the husband is ready to take care of the entire expenses. The party in person submits that the court has has failed to consider the fact that she was not working from 2021. Whatever the amounts that are credited to her account are with regard to the balance for the work she has done earlier, correct? For the work she has done earlier. And as on the day when she was not working and when she is in need of money to maintain herself, that particular aspect was not taken into consideration. And the parties are entitled for maintenance basing on the income of the husband and their standard of life, which the husband is maintaining. And even for the boy also, when she has to support herself and the boy, and the court simply grants an amount of rupees, grants only medical and other expenses, but not medical, educational and other expenses of the boy, but no maintenance to wife. It is submitted that the husband has an obligation to maintain the wife. Land counsel appearing for the respondent husband submits that except on the order passed by this court, the husband had no access to the boy. Had he filed any application?
No,
For
he
visitation
hasn't
rights.
filed. No.
And it is also an undisputed fact that the husband had never asked for any visitation rights, the boy. The visitation rights for the boy. It is submitted that they are ready to bear the expenses of the boy. And they've already, for the year 2023, they have already deposited, as per the order of this court, an amount of rupees 2 lakh is paid. And for the 2024,
the first installment has been paid.
For
of the fees.
2024, the first installment.
Of 44,000 has been paid.
44,000 is paid. 44,000 is paid. It is submitted that the wife has not come up with the actual figures with regard to her income and other things. And the court below rightly held that she is able to maintain herself and she do not require any maintenance. Next, having heard the party in person and the counsel the respondent, peruse the entire material on record. It is a case of the wife that she was working till what date?
30th November 2021.
30th
November 2021.
She was working till 30th November 2021. And the MC is filed when?
21st November 2021.
21st November 2021. She has to stop her job because of COVID or because of the responsibility?
COVID, Lordship, it was COVID, because if you see also the show
Because of the COVID, she has to stop the job and she has to take care of she has to take care of the boy. It is stated that the court below had failed to consider the said fact. In considering the income of the husband, this was she was not granted maintenance. This court has perused the order of the court below. This particular aspect with regard to the maintenance to the wife, from her statement, it appears that she has quit the job in October. only looking at the bank statement, the court ought to have taken the further bank statements also to consider the said fact, whether she is working or not. And this fact has to be, this aspect has to be considered by the court below. Considering the same, till as far as the wife's maintenance is concerned, both the wife and husband shall file their respective statements of assets and liabilities, and the wife has to file her the bank statements from November 2021 till now to show that she's not working. And basing on that, the court, and considering the income of the husband, the court shall pass appropriate orders fixing the maintenance of the wife. When it comes to the boy, according to the mother, the school for the whole year, whatever she was giving some breakup of miscellaneous expenses. The application is filed in the year 2023. For the boy, from 2023, what is that? March
3rd.
From 2020, for the year of 2023, including all the expenses, the 2 lakh, which is already granted, which is already deposited by the husband in the account of the wife, would be suffice for the said year for the expenses. Then when it comes to the educational expenses and the miscellaneous for the year of 2024. Now for 2024 also, towards everything paid towards the boy, for miscellaneous expenses and all other things, 2 lakh rupees.
Okay.
For this year also, for the educational expenses.
Yes.
Then apart from that, until the order is passed by the court, for whether the wife is earning or not, from the submission of the party in person, it appears that she is not working. The court, it is pending consultation before the court now, in the light of the orders passed by this court. But however, to maintain the boy and herself, she requires the maintenance has to be paid from, when is the petition filed before this court?
November again, my lordship.
Boy and the wife, the husband shall pay an amount of rupees 50,000 per month, pending consideration of further orders passed by the court below, from the date of this application till that is decided by the court below. The court shall decide the application on maintenance within 2 months from the date of receipt of the copy of the order,
Lordship, I have
which
one
is
more.
subject to the orders passed by the court below.
Yes, sir. Lordship, I have one more request.
Yes.
I would like to change the court below because I'm not being heard there.
That's not the way it is done.
You can check it, Lordship. I'm not.
That requires a different petition, different this thing. Just like that in this petition, court can't change. This court has no power to do that.
Lordship, in this petition itself, I've requested also for my.
You can't request like that.
No. I have requested my Sridhan as well, which was supposed to be returned, which has also not been returned. And
How
that
it will
is-
be returned now?
They have accepted, they have it with them.
Because please understand, there is a procedure for everything. If you know law, you will understand all that. Now, when you file it, they accept it. That's not the time that the Sridhana will
No,
be.
Lordship,
Once the MC is decided, it will be done. And just for that, when what you ask, if the judicial officer is not doing, that's not a reason for the court to transfer it.
No, I'm not asking for that. What I'm telling is, I should be given a fair chance to present myself.
Why don't you engage an advocate?
I
From the
did
legal
that.
services, you
Three
engage
advocates.
somebody.
Even he is not being allowed to speak in the
Lordship,
court.
3 advocates have been
Court
changed.
cannot have any, what is the special reason for the court to do that? Please understand.
Lordship, I should be given at least a fair chance to present myself. And the malpractices which are obtained by the respondent has to be stopped. If I'm not being able to represent myself, how will I?
Madam, serial number 20.
ಬರೋದು 3 o'clock. Court officer? Hello, court officer?
Passwords.
Serial number 45.
Oh.
I filed a memo for withdrawal.
45. Yes.
Interim order will be.
Memo is filed for withdrawal. Yes. Memo is for seeking withdrawal. The same is taken on record and dismissal is not all pending in the petition in interlocutory. All IAs are closed. Yes.
For petitioner. The last date of hearing.
Hmm.
There was an order directing me to produce a
Which
acknowledgement
is a case?
for 2 minutes.
Oh, yes.
There was a direction for me to produce the acknowledgement of proof of service on counsel representing the respondent in the trial court. We did try, but respondent counsel who was appearing for respondent here in the trial court, he refused to accept the. I filed an affidavit to that extent. I was told that there is a matter pending on 8th of this month before the trial court execution proceeding against the impugned order. So I'll try once again to serve the copy. In the meanwhile, I was.
Then take notice by RPAD.
I've already paid processment.
All that to happen, it will take another.
Correct me. I've already taken process anyways. The process is there. I've paid process.
Registry is directed to issue notice to the respondent. What is happening from 2019? Registry has not issued notice.
No, ma'am.
Notice is not sent. Why it is not sent?
Previously, what had happened?
Just show that. There must have been objections
No,
and
no.
now 2019 it has come up in.
On NOC method. Previously,
No,
what
let
had
us
happened,
see
there
what
was
has
a-
happened to the notice to respondents.
Notice was never issued, madam. Only your lordship issued notice on the
2019 petition till 2024 without notice.
no, what had happened? There was a direction for me to produce the payment details.
Prior to that. Court notice. Yes, post after service, service of notice. Yes, next.
Please.
Yes. Post is tomorrow. You're here? Yes.
There was totally 60,000 has been paid. Arrears is 1,70,000. From January 28th.
No, he said how much is the court granted? 20,000.
20,000 has been granted.
Uh,
So far 60,000 has been paid. 60,000.
no, 20,000 is granted by the court below and this court said you pay 10,000. How many months it was calculated?
17 months.
17 months.
So 1,70,000 to 2. From 28/1/23.
When was the petition filed?
28 January 23.
So 12 plus 7. 12 plus 7.
It will come to 17 months.
23 to this, I mean 24, 12 months. Now 7 months.
No, no, it will come to 17 months. 17 months.
Ah.
So 1,70,000 will add.
It comes to 19 months, not 17 months.
From
And
28
including this month also. By 10th of this month you have to pay. So 19th. So 19 into 10, 1,90,000. How much you paid?
60 has been paid already.
60,000. So you have to pay 1,30,000. Then goes to the petitioner submits that his take home salary is
31,218.
31,280 and the court had granted an amount of rupees 20,000 as maintenance and maintenance it is stated that in spite of the case of the petitioner was not considered by the court below, considering the submission, they shall be stayed or fall further proceedings pursuant to so and so on the condition that the petitioner continues to pay an amount of rupees 10,000 by 5th of every succeeding month. The arrears 10,000 by 5th of every succeeding month. The arrears for 19 months, it comes to 1,90,000. It is submitted before this court that after the orders are passed, an amount of rupees 60,000 is paid. Hence, the petitioner has to pay arrears of an amount of rupees 1,30,000 within 4 weeks from the date of receipt of a copy of the order. Either the default order, either 10,000 or this is not paid, the stay granted by this court stands vacated without further reference to the court. Post this matter on August 7th. The petitioner shall serve the notice on the counsel for the counsel appearing for the respondent before the court below and shall file a memo before this court by 29th. Yes. Is it the other day's matter? You have the instructions?
There are two petitions. The first one is calling in question the order condoning the delay and restoring the original miscellaneous petition. Now, my lord, subsequent thereto, an order has been passed in the restored miscellaneous petition where it has, the matter has led to quietus saying that the delivery report is accepted. Therefore, my lord, the first order merges with the final order. And the second order, my lords, is an inert order where it only says that since delivery report has been accepted, nothing suffices. I may have to challenge the very process of deliverable, and therefore I am filing the memo. These petitions may be disposed of, my lord, with liberty to challenge the.
Can't be given at this time. 2018-17 writ petition in 2022 because you have not
My lord,
2024.
I have challenged the first order itself.
Then that is liberty can't be granted now. At best, the order would be passed on
even-
merits, but no liberty.
But even the other side. that's
Because
considered-
court can't permit you for not understanding the remedy available to you from 17 to 24.
But even the other side conceded, my lords, that this.
That he said that the liberty be given.
Yes.
No, I don't think I've made such a submission.
No, he said, no, this is what has to be done.
Is it so? That you want the court to give a liberty to him to question that delivery warrant now, of which year?
This part was not discussed, my lords. What I had submitted was, and brought to my lord's kind notice that the order that is questioned is an inert order. That was my submission.
Yes.
Of course, incidentally, I had said that if at all he would have questioned something, that would have been the bailiff's order.
Correct.
That was my submission.
I remember that.
So I'll have to challenge the bailiff order. Or else-
That you have to test it on its merits. If you question it, if the court feels that wherever you're questioning it, it is right.
But that has to be questioned before this court.
No, when you come up with an application in 2024 and you explain to the court the delay and why, then you have to succeed it on the merits of it. But there can't be a liberty. Absolutely no.
Not because your lordship will kindly see the first order. It is 13.
That is true. It is not that. I can understand that instead of filing, for example, a remedy of something, you have an MFA, you filed something else, a writ petition is filed, and you are prosecuting the litigation before this court. On that ground, I can understand.
Lordship will kindly. The first order is 13/12/2016.
13/12?
2016.
Yes.
That is already challenged in WP number 29750 of 2017. This order, what happened, my lords? The respondents before my lords had filed were auction purchasers for the purpose of taking possession of those properties which was purchased in the auction purchase. They filed miscellaneous petition 59/1995.
I remember all your submissions on the last occasion. There are so many miscellaneous petitions. Sir.
Yes.
Yes.
They filed miscellaneous petition 59/1995.
Tell me, when was the delivery warrant issued?
Delivery warrant order. Give me the second petition. The delivery warrant has been issued on 15/9. Subsequent to 15/12/2016 minutes.
So tell one good reason why liberty has to be
After
granted.
15, your lordship, 15/12/2016, thereafter I filed an application to recall this delivery warrant. The court and also report death of the person against whom delivery warrant was to be executed. But the court comes to the conclusion that since the LRs have only filed memo, but they have not come on record themselves. And it was the my lord's duty of the miscellaneous petitioner to make appropriate application to bring the legal representatives of the deceased on record. The court says, anyways, now this cannot be, the court says, delivery warrant has been executed on a dead person. It makes no consequence and it just closes this petition by way of this order. Your lordship may kindly see the order which is impugned in WP number 48458 of 2018.
First petition.
Second petition.
12.1. Yes. Yes. Page number?
Page number 32.
30.
Page 14 of the order. 32.
Order starts at 19.
Order, the operative portion of the order.
Is it?
Starts at page 24. In the second petition, 48458 of 2020.
I'm looking at that. 48458.
Yes, my lords. In page number 32, internal page 14 of the order. Impugned. The operative portion of the order is the petitioners have given delivery receipt wherein they have stated that they have taken up the delivery of the movable property stated in the petition and closure of the case. In view of the court, this court has accepted the report of the bailiff and receipt of the petitioner. By this, the purpose of filing this petition is served. Accordingly, case is disposed of. This is what is challenged immediately after this order.
Let us see what are this IA number 9, IA number 11. What is that you sought?
This order is passed on memo as well as IA number 11. And
So what is this order is, the respondent number 2 has filed IA number 11. Third para.
Yes.
With a prayer to restrain the petitioners from trespassing into the petition A scheduled properties. That is the IA,
And during the
which came to be dismissed.
And during the pendency of this application, the person who filed this application died. That is reported to the court. If your lordship takes the order sheet, if your lordship takes the death certificate notes at page 123.
Yes.
But the date of death is 25/2/2018. Now, your lordship may kindly see the memo also which was filed by the petitioners. That is at page 122. This is filed on.
So, for example, now I allow this writ petition. What are the consequences of it?
Because if this writ petition is allowed, the matter get restored to the state of still miscellaneous petition for 10/2004.
By that time,
My lord.
still, this is delivery warrant is not part of it. Delivery warrant is not part of it. That is still unquestioned. So how would the court also can put it back?
Your lordship may kindly. There are two miscellaneous petitions. The first miscellaneous petition which is now included is miscellaneous 10/2005.
Yes,
That is in
it is
the
not 10, it is 11.
10/2004. 2004. That is in the first petition.
What is this number? What is this IA?
My lords, in miscellaneous 10/2004.
Let us see the IA. What is IA? Seeking restoration of miscellaneous number 59.
Yes.
What is this miscellaneous 59?
Miscellaneous 59 is to take possession of the auction purchase property. So this miscellaneous petition, the restoring of miscellaneous petition 59 by allowing miscellaneous petition 10/2004 itself is in question because of this reason, my lords. My lords, in the earlier round, my lords, when the petitioner had come, when the petitioner had come before this honorable court, what happened, my lord? This miscellaneous 10/2004 was filed to restore miscellaneous 59 without filing an application for condonation of delay. In spite of this, the trial court had allowed it. That was challenged by filing writ petition before this honorable court. That is in WP number at annexure D of this petition, lords, page 47. If I take your lordship to page 47. Page 43, my lords. The order starts at page 44.
Any of the pendency of this writ petition which stopped you from publishing the delivery warrant?
No, this is subsequent. The petition was pending before the honorable court. In spite of pendency of this writ petition, the trial court proceeded.
Correct.
The process.
No, there can't be any bar to the court below to issue a delivery warrant. It issued.
It issued delivery.
We should have questioned it.
We have questioned it, my lords. Probably in a writ petition, it is not sought for, or else I will do one thing, my lords. Your lordship may permit, I will amend the writ petition. It's only what I have challenged is the order which is passed about simultaneously, but not the order delivery warrant.
What the court is not giving you now, you want to have it the other way.
Yes,
How can you amend the prayer now?
Your lords, if I was not diligent enough in filing anything, my lords, then your lordship may be. but I have filed at an appropriate.
You take your chance by doing that.
Please.
My lords,
What's this matter?
the answer to the submission made by my learned friend is at internal page 14. The Honorable Court records the clear finding that the warrant was issued and
Executed also.
yes, during lifetime of the second respondent. So nothing survives.
Nothing, sir. It has to go. Anyway, he wants to take a chance. Let's just see. We'll post this matter on 16th. Whatever you want to do that day.
Please.
Yes. Yes.
First petition is from the wife, seeking enhancement of compensation.
Who appears to
Second petition
respondent?
is reduction they have filed. They obtained the stay in 2022, subject to payment of 10,000. Granted with 20,000 was granted by the family court. Even that amount they have not departed. Therefore, annual IT holder, the husband is IT holder. As per the.
You are seeking enhancement of maintenance.
I am seeking enhancement.
What is the amount granted?
Amount we paid 30,000 per month for child and female child and wife.
What is the income of the husband?
Husband is as per the 80 millard, 5 lakhs net income has been final.
How much the court has granted?
20,000.
Come to the order. Where is the order?
Not
Millard, page 30 annexure.
same. 5 lakhs. ಅಲ್ಲ ಇದು 20,000 ಆದ್ರೆ ಅದನ್ನ ಪ್ರೆಸ್ ಮಾಡಕ್ ಹೋಗಲ್ಲ ಅಲ್ವಾ 10,000 ಆಗಿದೆಯಲ್ಲ ಏನು ಪ್ರೆಸ್ ಮಾಡೋದು ಬೇಡ ಆರ್ಡರ್ ಇಲ್ಲ ಅದು ಎಂಟ್ರಿ ಮಾಡ್ರಿಲ್ವಾ ಈಗ arrears ಕೊಡ್ತೀಯಾ
Yes.
He is the owner of 4 lorries and he has got yellow bird 3 cars, and 5 acres one is commercial land, actually getting 50,000 per month from that land, and also has a building rent for the rent income per month is 1 lakh rupees. Whatever the document.
But you are not filing an execution.
Execution I have filed, in view of the interim order granted by the Honorable Court, they have
Interim order.
in a connected matter.
Lord, may I make one submission? This is the wife's petition. Insofar as the husband is also challenged the order of the.
Yes.
In that matter, my lord, which was challenged before this honorable court had passed an order restricting it for 10,000. 20,000 was reduced to 10,000.
Are you complying with the interim order?
Complied, my lord.
Is it so?
No, my lord.
No, I will
They are
comply, my lord.
complied.
Sir, one.
When is the order passed?
Passed on 3rd January 2023.
2021, this is 2022 writ petition yours.
My lord, insofar as WP 25926 of 22 is concerned, it was filed on, the order is on January 2023. I have paid some amount. I will pay the rest of the amount as per the order of this honorable court. This is my first submission. My lord, insofar as my second submission is concerned, my lord, my learned friend has also produced his my IT returns. My lord, I own a sum of rupees 5 lakhs a month. This is my earnings, my lord. That apart, I don't have any other earnings. My lord, out of 5 lakhs divided by 12 is 40,000, my lord, per month. 20,000, the court has passed an order. If your lordship may confirm that order, my lord, I will withdraw this. I will pay 20,000. I'll withdraw my petition.
Said that it is divided by something is so and so.
My lord, 5 lakhs divided by 12.
You mean to say 5 lakhs per annum?
Per annum. Per annum. Therefore, I'm getting only 40,000.
No, he stated something like per month.
No. Kindly see, my lord.
Please come to the discussion in the order.
He earns. My lord, your lordship is referring to page 36, my lord. 36 and 37. My lord, monthly income of 1 lakh. My lord, this is the submission of my learned friend before the trial court.
No, what is, you might have filed your statement of assets and liabilities.
Please, my lord, it is filed. It's only 5 lakhs that I earn per year. Income tax is only 5 lakhs. That apart, my lord.
Court gives no finding with regard to your income.
Please, my
Court,
lord, that's not there.
Basing on what you're saying that his income is
No,
3 lakhs.
Is there, my lord, as per the lordship, it is the open secret, my lord, while declaring to the income tax.
How can it be open secret?
According to my submission and assets and liability, I have produced before.
Though it's an open secret, but still a secret, court can't consider it.
Sir, please, my lord, it is true, my lord, the 5 acres land is there. It is true, my lord, 5 lorries he is running and supplying the water. And it is true, my lord, he is receiving 1 lakh rupees per month as a rent income.
How is
it is true, my lord, he is doing his real estate, my lord.
No, don't say everything true. Now you're saying that one is income tax, you say that what he says is right.
Other, my lord.
Though he's, 1 minute, though he's having income, but he has not disclosed it. That's why income tax return shows only 5 lakhs per annum, one submission. Second submission is rent, he's receiving 1 lakh per month. Where is the material for that?
Document is, it is very difficult to produce document to that.
But court only have to look at the document.
Real estate business, he is doing real estate business is doing. He is also receiving.
Please tell something which you can justify.
Lordship knows, all those profession.
My lord doesn't know. My lord, my learned friend cannot say my lord knows that. No, the court is not supposed to know that.
He actually doesn't mean that. What is she has a child also. No, in that case, no, in 40,000, half of it you can't give her. The child is also there.
20,000.
20,000 is what the court has granted.
Please,
it should be more. What about you alone will have 20,000 and the child and the mother for both of them, how can it be 20?
My parents are there. My grandmother is there. I'll have to take care of all of them.
They have own house, my lord, and also his mother-in-law.
Agreed with the order passed in.
If your lordship may kindly see for a moment, the conduct of the petitioner also. In my petition, my lord, page, I'm sorry, in 25926 of 22. If your lordship may, for a moment, my lord, kindly turn to page 24 of the petition, my lord.
Page number?
Page number 24, paragraph number 6. My lord, I don't want to read that, my lord. If your lordship may kindly look into it, my lord. Just for the purpose of arguing, I don't want to argue, my lord, but the fact is that.
Agreed with the orders passed in. I number 4 in MC number 818 of 2018 dated 20th March 2020. Both the wife and husband are before this court. for the sake of convenience, they referred to as wife and husband. WP, the wife had filed WP 15468 of 2021, and the husband has filed 25926 of 2022. In the petition filed by the husband, when the matter came up for admission, this court on which date?
My lord, on 20th March 2020, my lord.
On
No, this court, my lord,
Interim.
it's
Something
on January
January, is it?
23, my lord,
January,
23,
take
2000.
that docket proceedings in the second matter. On 3/1/2023, had granted stay on the condition that the husband shall continue to pay 10,000 till the appearance of the respondent. So now when he appeared from that day, you don't have to pay then till the appearance of the respondent. The counsel appearing for the petitioner wife submits that the MC was filed seeking by whom?
Husband.
MP was filed with the husband seeking divorce. And in that, the IA is filed seeking interim maintenance at rupees 30,000 per month for for herself and for the child, and also 25,000 towards the litigation expenses. It is a case that as in view of the differences between the parties, she had left the matrimonial home. And out of the wedlock, they were blessed with a baby girl who is aged 4 years. According to the wife, she has been taking care of the child and paying the school expenses. According to her, the annual pay is 60,000. And she has paid 50,000 by borrowing the same for her father. And she need to pay a balance of rupees 10,000 towards the school fees. It is a case that the husband is having 4 water tankers. He owns 3 cars and 2 bikes. And he is earning an amount of rupees 10,000 from the business. He is having agricultural land to an extent of 5 acres. He earns about rupees 50,000 per month from the agricultural lands. He engaged in real estate business and earning rupees 50,000 per month from the said business. And also has a own house. And in spite of his income, he has not taken any efforts to, he has neglected to maintain the wife and the child. The husband filed his objections to the statement. Stating that he himself has taken care of his daughter and he has spent each and every time whenever he need to take care of expenses of the daughter. And he also waited for the respondent to realize her mistakes and lead marital life with him. And he is paying the school fees of the daughter also. And as far as his income is concerned, the same was denied by him. The court below, considering the expenses that the wife is incurring towards the school expenses and also looking at the business of the husband, had granted an amount of rupees 20,000 per month towards interim maintenance. No amount for litigation expenses, but no amount is granted for litigation expenses. Land counsel appearing for the petitioner wife submits that though the husband is earning sufficient amount, the court had granted only 20,000. It is submitted that though he could not file any document about his income towards his business, his agriculture and other works, but he is earning more than 3 lakhs per month. These aspects were not considered by the court. According to him, right from the date the order is passed by the court, no amount is paid by the husband. Next, the land counsel appearing for the respondent husband submits that the court had failed to consider what is the income without giving any finding and just basing on what has been stated by the wife, had granted an amount of rupees 20,000 towards interim maintenance. He submits that except stating that the husband is earning by doing business, no other material is placed before the court. So that for that the court has to come to the conclusion. It is submitted that the amount that is granted is on the higher side, and the same is granted without any basis. Land council further submits that as per the orders of the court, they have paid certain amount, some amount, and the remaining amount would be paid. Next, having got the counsels on either side, where is the material on record? The wife had filed the petition seeking maintenance of an amount of rupees 30,000. No doubt, as contended with the land counsel for the respondent, the respondent husband, the wife, having stated that he's earning more than 3 lakhs, had not filed any material to show that on what basis she's saying she's submitting the same. But the income tax returns filed on behalf of the husband shows that his annual income is 5 lakh per annum. Apart from that, it is not disputed that he's having agricultural land and also a own house. Considering all this, without considering going into the aspect of the 3 lakhs amount, basing on the admitted things, this court deems it appropriate to grant an amount of rupees 25,000 towards maintenance to the wife and the daughter. Accordingly, the writ petition filed by the husband is dismissed, and the writ petition filed by the wife is partly allowed.
Lord, insofar as 25,000 from this day, my lord,
25,000 is from the date of order.
from the date of order of this honorable court.
This court. Today.
Great.
Yes.
Here for response.
Yes.
Preliminary issue regarding court fees. Lord, it was held against the defendant, and trial court held payment of court fees appropriate, against which this writ petition is filed.
Let's see the order.
Yes.
Yes.
Lord, just I narrate the facts of the case. Lord, suit for initially filed for bare injunction, restraining alienation of the property.
Yes. Thereafter, declaration is sought.
Thereafter, they amended the plaint and included the prayer of declaration of that certain sale deeds executed in respect of the scheduled properties were not binding upon the plaintiff. But in the plaint, they contend that they are the co-owners, they have a share in the property. However, surprisingly, suit partition relief is not claimed. A suit for bare injunction is filed, contending that they have a share in the property. Lord, we filed a written statement disputing the claim, disputing their title also. So additional issues were framed, including the issue regarding court fees. Lord, one contention was, as it is virtually amounts to cancellation of the sale deeds, Section 38 should have been invoked for calculation of court fee. But secondly, I would contend that Section 26C of the Karnataka.
Oh, let's read
Yes.
the order, then you can make your
Yes,
submission.
yes.
Please come to the order.
Yes.
Starts from page number 46.
Please come to para 21.
It is to be seen that initially the suit was for permanent injunction restraining defendant from alienating suit properties. It is a claim of the plaintiffs that they are also the legal heirs of deceased John D'Souza. Hence, they are entitled for a share in the properties which belong to John D'Souza. The defendants are illegally alienating the suit properties and they have been restrained from doing so. Later, the relief of declaration that the sale deeds executed by defendants to third parties are not binding on them came to be added. It is seen here that the relief of permanent prohibitory injunction is not a consequential relief, and the relief of declaration that the sale deeds are not binding on them. Even in the absence of the relief of declaration, the suit for permanent prohibitory injunction was filed. Therefore, the relief of permanent injunction is not an ancillary relief. Therefore, the facts of the case of V. Prabhakar stated supra is not applicable to the facts of the case. It is to be noted here that sale deeds dated 35-15 and 110-15 are executed by some defendants to third parties. The plaintiffs are not executors of these sale deeds. Since they are not executors of these sale deeds, they need not seek an annulment of this document. However, they have sought for declaration that the sale deeds are not binding on them. If the non-executant files a suit or claims a relief that the deed is not binding on him, he need not pay court fee on the market value, or suit need not be valued under Section 38 of the Act. Value of the said relief under Section 24D of the Act is sufficient. In this regard, the Honorable Supreme Court of India in the case of so-and-so in AIR 2007 SC 2807 held as under. That citation is quoted there. Then as per the above said ruling, the plaintiff being non-executor of the document need not pay the court fee on the ad valorem value. The suit need not be valued on the market value of the suit properties, plus a fixed court fee is sufficient. The argument of the learned counsel for the defendant that the plaintiffs are not strangers, they claim to be co-sharers. Therefore, the above said ruling is not applicable to the case as force. And the Honorable Apex Court has held that non-executant of the document can seek for declaration of the document as not binding, null and void, even if he is a co-sharer. If he doesn't execute the document, he becomes a stranger to that document. Thus, the above said ruling is applicable to the facts of the case. Section 50 of the Act says, if no specific provision is made in the Act, value for the purpose of jurisdiction will be the same as that of the value for the purpose of payment of court fee under Section 24D of the Act. No special provision is made to value the jurisdiction. Therefore, for the purpose of jurisdiction also, suit has to be valued under Section 24D. But the first relief that is claimed is a permanent injunction. Title is asserted by the plaintiff in the plaint. That is denied by the defendant in the written statement. Lord, 26C may kindly be seen, my Lord. The Lord, property belonged to one John D'Souza. He died. Lord, he and his wife executed a will in favor of the first defendant. Lord, first defendant acquires the property. Court Fees Act.
Court fees. Yes.
So plaintiff's claim is that we are the brothers and sisters of John D'Souza. The will they deny or they dispute, and they say we being the brothers and sisters, John D'Souza had no other children.
Different defendants or brothers and sisters?
No. Lord, John D'Souza was the owner of the property. And Teresa D'Souza, his wife, Lord, they died issueless. Plaintiff's claim is that we are his brothers and sisters. Therefore, we are entitled to the property. Well, the first defendant claims they executed a will. Pursuant to the will, he acquired the property. And based on that, he alienated the property to the second defendant. So the defendant denies the title of the plaintiff.
You are the second defendant.
Second defendant. Now, 26C may kindly be seen. Well, 26, section 26.
Yes.
Suit for injunction.
1 minute.
Yes. In a suit for injunction where the relief sought is with reference to any immovable property and where the plaintiff alleges that his title to the property is denied, or where an issue is framed regarding the plaintiff's title to the property, fee shall be computed on 1/2 of the market value of the property or on ₹1,000, whichever is higher. Here, Lord, 26A1 would apply. Plaintiffs in their plaint clearly state that the defendants are interfering, they are denying their title. In spite of that, conveniently they file suit for bare injunction. no declaration or partition.
That if it is
It's
maintainable
it's
or
their
not.
choice. But even if it is for simple relief of permanent injunction, because title is alleged and denied, 26A1 would apply.
Hmm.
And half of the market value, they have to pay the court fees.
Please read full. Fee shall be computed.
Where the relief sought is with reference to any immovable property and where the plaintiff alleges that his title to the property is denied, or where an issue is framed regarding the plaintiff's title to the property, fee shall be computed on one half of the market value of the property or on rupees 1,000, whichever is higher. The higher is the market value only, half of the market value. So they should have paid court fee on that.
Yes.
So that is my contention, my lord, and I am relying upon
Yes.
ILR 2002 Karnataka 3512.
Yes.
Lord, on quoting section 26, Lord, it is held that from the reading of the above provision, it is clear that in either of the two situations contemplated under section 26A1 or 2, the court fee has to be computed on with reference to the market value of the property. So therefore,
Yes.
this provision has not been appreciated by the trial court. Therefore, they have to pay court fee on half.
My entire plaint, my lord, I have never said my title has been denied.
May I read it? No?
Yes.
I see. Yes. Yes.
Let them point out where I have denied.
Yes, yes.
My first submission. And in this suit for declaration, my prayer may kindly be looked into. That for a declaration that sale deed dated so and so, registered document number so and so, is void and not binding on the plaintiff. So I have not asked for cancellation. There is a direct judgment of Supreme Court, which I would like to point
That
out.
is extracted in the order, I think.
Yeah, same judgment.
First one. That extracted portion I have seen.
Yes.
Yes.
Para number 7 is important.
Para 7.
Para 7.
Hmm.
Where the executant of the deed wants to annul that he has to seek cancellation of the deed, but the non-executant seeks annulment of the deed. He has to seek declaration that the deed is invalid and honest or illegal or that it is not binding on him. The difference between the prayer for cancellation and declaration in this regard to the deed of transfer conveyance can be brought out from the following illustration. A and B, two brothers. A executes a sale deed in favor of C. Subsequently, A wants to avoid the sale. A has to sue for cancellation of the deed. On the other hand, if B, who is not an executant of the deed, wants to avoid it, he has to sue for a declaration that deed executed by A is invalid, void, and honest, and he is not bound by it. In the essence, both are suing to have deed set aside or declare as honest. But the form is different and court fees is also different. Here, even according to them, I am not a party to that sale deed. So I did not pay on the market value. I can just ask for declaration that is not binding on him.
Yes.
Direct judgment of Supreme Court.
Yes, heard, reserved.
Lord, one submission is, my contention is twofold. 38 is one contention. Yes. Because declaration amounts to cancellation. Therefore, 38 should have been invoked. If 38 is not applicable, 26A1 is applicable. Lord, in the plaint, there is a clear allegation that we are the owners. The defendants are alienating the property. They are questioning our title. Lord, I will not trouble reading the whole paragraph. But there is definite allegations
There
that
is
the
absolutely
defendants
no
are
allegation.
interfering with their title.
There is
That is why
absolutely
they
no
are challenging
allegation.
the sale deed.
Yes.
I appear for the petition and the connected matter.
Yes.
We had pointed out last time, I made submissions last time, it was on the issue of maintenance. There were 2 applications filed in a proceeding. Maybe I'll just recapitulate.
You're appearing for sir?
I'm appearing. Others was representing the children, and this is only for maintenance for the children.
Where is the order?
Lordship may kindly come to page 26.
26. Yes.
The father, my lord, has not paid any maintenance at all. May I? And my lord, this is an order where there's no consideration of any of the evidence at all. Please come to para
Both
9.
of them are again married.
Both of them got married again, but the second husband of mine refused to take care of the children. So I had to leave, my lord, and go back to my father and my brother. So my father and brother have been taking care of me and my children and have paid their school fees. Every single expense of theirs has been met by the father, and the father, my lord, is a retired person. Lordship may kindly see para 19.
How much is awarded?
3,000 rupees a month. I can only say, my lord, this is, Lordship may kindly see the reasons given at para 20. 20, para 20. It is an admitted fact that first daughter has completed her BE education and distinction, and now she's working. That's now. Petitioner taking contention, now the first daughter is working and getting salary. There's no necessity to pay the maintenance amount.
So why
Admitted,
are you seeking maintenance for this earning daughter?
not for earning daughter. It was
The other
still,
one.
it was still, no. It has been pending for a long time.
When was it filed?
Not the 2013,
And order came to be passed on?
24, 23, 11th December 23. And therefore, my
No
lord,
interim maintenance was granted in between.
and my lord, therefore, we have given all the records of all the payments made towards educational
So
expenses.
when this daughter has completed her BE?
B, my lord, when she turned, I think, I'll just give you lordships that date. But the court, anyway, my lord, that may or may not arise because the manner in which the court has calculated the compensation is on some kind of an assumption that there is an order in the High Court saying you have to pay that much, and therefore that's all that has to be paid. And let me just quickly take your lordships. It's only 2-3 paragraphs where there's absolute non-consideration, I would say. Admittedly, in page 19, third line, admittedly, maintenance amount is claimed by children prior to attaining the majority. When they were studying and required the amount, at that time, they've claimed the maintenance amount. Without waiting for payment by the father, mother of the children, by taking assistance from her father and brother, completed the education of children. Now, the petitioner cannot avoid his responsibility taking such a contention. Both children are studying at standard school, completed the education with hard work, and the result is also distinction. Admittedly, petitioner had paid interim maintenance of 3,000 each to the children as per order of Honorable High Court. There's no order of any court, my lord. According to petitioner, after deducting that amount comes to 1,89,000. He has calculated arrears which comes to 4,65,000 and has already paid 1,44,000 before the Honorable High Court. Arrears is only 3,21,000 and he is ready to pay the amount. It is a liability of petitioner to pay the school fee of the children. IN number 11. Respondent claimed 1,98,000 school fee of children which was taken by her from her father and brother. That was for 1 year.
Which order of the High Court they are referring to?
There is no order, I don't know which order it is. There is no reference of any order. There is no direction to pay 3,000 rupees maintenance. And nothing is placed before the court. And on that basis, my lord, for 1 year in IN number 11, we said you have to pay immediately the school fee, which he did not pay. That was 1,98,000. So the court says that is to be paid. But I have led evidence to show the entire calculation over the years of how much school fee has been paid. And there's no dispute on the amounts at all. Not a single dispute raised, my lord, with respect to the amount spent by us.
Marriage expenses at 8 lakhs each to the children.
8 lakhs to the children. 1,98,000 is for 1 year school fee, 1 year's school fee. And 3,21,000 was arrears of maintenance. But the whole direction was that the court must consider what the maintenance amount is and make a determination. There's absolutely no consideration, and all the material, my lord, has been completely ignored.
We'll ask.
Very well.
Yes.
May it please you, my lord. My lord, your lordship may come to my
writ petition 7838.
No, before you proceed,
Yes.
High Court, in which case has directed to pay 3,000, where is the order?
Order is dated 18/10/2016, my lord.
18/10/2000.
18/10/2016.
Is it filed?
It was it is not filed here. In another criminal case, it was ordered. In another criminal case, it was ordered.
You have a copy of it?
Today I don't have. I'll produce it. I have a copy. Today I don't have a copy.
The criminal case?
I thought they would not engage me on this or this court. I will produce this order of the court. It was a considered order and the other party was also present. 3,000 each was given to the child. It was 13 years ago. At that time, that 3,000 was very good amount. Now it may not be good amount, but I have paid up to the age of their attaining majority. I have paid up to date. 6,000 for 2 children. This is one aspect of the matter.
Then what about the school fees and other things?
School fees is, my lord, maintenance is not defined anywhere in any book. I have been making a research on this. Maintenance is not defined in any act, Family Court Act, Hindu Marriage Act, Maintenance Act, nothing. It is by the rule, by procedure, by precedents, by judge-made laws. We have come to understand that maintenance is food, tuition fees, medical fees, their transportation. Therefore, the second order passed by the learned trial court judge asking me to pay school fees is a part of maintenance.
No, before that.
Therefore, my submission is there cannot be a maintenance for transportation, maintenance for food, maintenance for fees. That's my submission. My submission is 3,000 plus 3,000 for 2 children
No,
or
1 minute.
inclusive of all this.
In a criminal proceedings, that order is passed when? Which year?
18/10/2016.
18/10?
2016, 1/6.
This petition is filed?
This
No,
petition
that
is filed
not
in
that
13.
criminal proceedings is not something about a maintenance. No, when the petition is filed before the court, when the evidence is let in, court has to independently decide it, how much is the maintenance
Yes.
you're entitled.
Yes.
And after determining the maintenance,
Yes, ma'am.
then this much of amount the father is already paying,
Yes.
deduct it, and then fix the maintenance.
Yes.
But that is not done by the court.
No, my lord, it is not challenged. You are very much there for the past 10 years fighting the case in the court and you did not challenge this 3,000. 3,000 was agreed, was ordered and I paid 1,40,000 on that date I paid.
Unfortunately-
And there was no objection. You did not file an application for modification.
No.
You did not file an application for 10 years.
Without an order copy being on record either before the court below.
I'll produce
Or
one.
before this court.
Yes, ma'am.
Now we are talking about something of 6,000 and but unfortunately court below cannot say High Court has asked in granted 6,000. So I will also do.
My lord,
This is an application.
It's not like that.
Application.
It's not like that. I'm sorry, my lord. It's not like that. It was adjudicated. It was consented. Parties were present. It's not an ex parte order. We were present. And from 16 onwards till today, 2024, you have not raised your little finger saying that it is more or less. You should have applied for a modification, applied for enhancement. That is not there. That is what is called as acquiescence. You have accepted and I have paid and you have accepted also. Therefore, you cannot now go back and say, this after 10 years in 2024, when the girls are drawing 1,50,000 salary. No, please sit down. I did not interrupt you.
I will take instructions from the
No,
court.
please
not
sit
from
down.
you.
Please sit down.
Tell me to
My
sit down.
lord, this you have raised when the 2 children have become majors 4 years ago, when the 2 children are earning 1,50,000 per month, and they don't have courtesy to tell me that they are doing this.
No, this IA
Your
is
lordship
filed-
may kindly take.
IA is filed in 2013.
Yes, no, my lord, petition is filed. IA is filed in 16. From the date of filing the
When
application.
is IA filed for interim maintenance?
Interim, my lord, this maintenance has practically become the final maintenance today. Though it was initially an application, it has become final
No,
maintenance.
whenever it is.
Yes.
When is it filed?
My lord, the application was filed on 27/3/2013.
27/3/13.
2013.
Yeah, right.
And 14/6/2013. That IA number 10 is filed on 27/3/2013. IA number 11 is filed.
Finally, the court has passed a final order in the petition itself.
In the
No, it's on IA.
1 minute.
IA 10 and IA 11.
Lord, I think I should explain this. Please see the page 111 of my petition. This order dated 18/10/2016 is here. This is the order.
Which page?
Page 111.
Yes.
This is dated, no lordship will see on the top.
Mm.
18/10/2016. Page 111.
Oh, this is the one they're referring.
This is the order. Now, your lordship may kindly see this order.
18th October
2016.
2016. And this is
This is
arising out of?
in the GNWC case which they had filed for custody of the children.
Hmm.
We had filed an application for maintenance. Then, Lord, when the applications were being heard, they withdrew the petition. The question was, should these IAS be considered notwithstanding the so-called withdrawal? That was being considered. Your lordship may kindly see the order, para 6, at page 115. That apart, it is no doubt true that the main petition is filed by the respondent herein seeking that the respondent be appointed as guardian of the minor children. That is my learned friend's clients. It is in such proceedings by invoking the inherent power of the court, an application is filed with the petitioner herein with whom the children are residing, seeking for appropriate orders of payment of school fee. In fact, that was one of the aspects which should have required consideration by the court below, since when the petition seeks appointment to the respondent as guardian of the minor children, whether the respondent is interested in taking care of the welfare of the children is also one of the aspects which should have weighed in the mind of the court below. And if such consideration was to be made, certainly the court below ought to have taken note of the contention on merits to come to a conclusion as to whether the respondent is capable of taking care of the children. And in that light, whether the respondent is to be directed to either pay the maintenance or the school fee by taking into consideration merits of the contention and expenses as claimed by taking note as to whether such amount has been expended on the children and to what extent the respondent should be held responsible for maintaining children in the context. And that is how these IA 10 and 11 were directed to be considered. From that date till 2024, my lord, these applications have been pending. And now it is considered saying simply on a statement made that 3,000 rupees was paid by me and therefore that is the amount of maintenance and therefore nothing more has to be paid. You must not look at any of this voluminous evidence that we have placed before the court pointing out as to what is the exact expense. We are not asking for profit, not here. It is not a profit. You are a father, you must take care of the children. That's the least you can do. Educational expenses, food. Is this lady is not working? She does not have the ability to work. Now she is at least ensured, my lord, with the help of a father and a brother, children have been given an education. Otherwise, the children would have been on the streets today. And today the father is saying, I'll pay 3,000 rupees, that is maintenance.
Yes, my lord. In 2013, 14, 15, 3,000 was a good money for me. I am not a businessman. I am only a software engineer. Your lordship may kindly permit me to say a few background of this. My learned friend has not stated any background. My lord, she is the daughter of a high court judge. He is the daughter of a tailor. Because he was a BE graduate, handsome, simple man, honest man, you married your daughter with him. And from day one till today, you are harassing me. A small instance, I may bring it at the request of this honorable court. There are many instances where I have been abused, humiliated, and thrown out. One small instance you may permit me to submit. When Mr. Mujib was here, a registrar of this honorable court, he arranged this marriage. And when there was difference of opinion between the husband and wife, he tried for a compromise. A compromise meeting was arranged in a mosque. Justice, the father of the lady, comes with his official car with red light and 2 jeeps, police jeeps. No, please don't disturb me. I have the facts. After all,
maintenance is not about the father. I'm sorry.
Based on the facts. I am taking permission of this honorable court, bring you to your kind notice how he treated me How the wife also is responsible for this tragedy?
Whatever it is, that would be considered in a case where on
She is a
on
BSc
matrimonial
graduate.
case- No,
She is
let's
healthy.
not
She
go
must
into
have
all those
taken
stuff.
an appointment and looked after her children also. And you have no, I would now your honor doesn't want to permit me to say that, give this information or incident. I would request my lord to see page number 64 of my book. Would you even now, would you direct me to pay the maintenance, my lord?
Yes.
Please read this. My lord, they didn't want the father and the children to be met. There are incidents which my learned will object, and your lordship may also not permit me. I'll just read this, my lord. This is an application filed by the lady, the wife. What they say is, this honorable court may be pleased to pass an order prohibiting the opponent petitioner, me, husband, entering and visiting their children's, that is, Moina Yufra and Hajira, present school, namely Holy Angels High School number 2, 5th Main Road, 4th Cross, RPC Layout, Hampi Nagar, and their any future schools, colleges, hostel of their future studies, and visiting at their residence, and from attempting to communicate in any forum whatsoever with these aggrieved children, Moina Irfan so, including personal, oral, written, electronic, or telegraphic contact.
Yes.
In the interest of the protection and promotion of their welfare and healthy development, and in the ends of justice. Fine words, but butters no parents' nips. These are the words used by them. What is the law about this? I wanted to bring it to your lordship's kind concern. The law is, once the daughters do not want to engage themselves with the father, do not want to maintain relationship with them, they cannot claim the maintenance. I would submit 3 judgments to that. Yeah, disentitled.
Is it so? They
Now
never
they
had a
filed
contact
today,
with the
day after
father?
yesterday, day before yesterday.
There's a report of my lord, a councillor who was appointed in 2014 to ensure that the children meet the father. And I have stated the report in my objection statement as to what was said and what happened.
Take the judgment.
These 3
Where did you say
judgments.
so?
My lord, in our objection statement, we've extracted that
Page number?
page in the objection statement, my lord, the third page. We have extracted that report in the objection statement, my lord, to his writ petition. In 7838, 7838.
Yes.
Yes, in that, my lord, the page number 3.
6.
I beg your pardon, page number 3 of the statement of objections. In the objection statement itself, we've extracted that report. Your report copy. No?
Yes. Where is that?
That we've extracted the entire report here itself, because I'm told, my lord, the copy was very blurred. My report
in
in
compliance
compliance.
with the honorable court's order.
Yes, yes. And communication made to me. Both children, so and so of the petitioner Azimullah Khan, were brought to mediation center by maternal uncle. One Ul Haq, because not mothers there, they said anything will happen. Children's mother had not come to the mediation center, accompanying the children. Petitioner presented the mediation center at 3:30 and said children's uncle left the children free to meet and converse with the petitioner, father in the mediation center room, by keeping himself away from the mediation center. Petitioner started talking to them, but the children remained silent. I found them in a scared mood without responding to the gestures of the petitioner father. After a little while, both children went away from the petitioner father and joined their uncle, who was sitting far away from them. Then I made them come back to the petitioner father, sit near him. I told and wanted them to be talking to the petitioner. Curiously, both children started spontaneously weeping and crying and did not talk to the petitioner. After some time, in a sad and scared condition, children again quietly went away to the uncle.
Yes, I've seen that.
And my lord, I must point out to you what happened. One night, the mother and the 2 children were thrown out into the streets by the father and his mother. And my lord, on the street, they were in the middle of the night. They were on the street, and thereafter, my lord, all of this problem happened. So to make allegations and in the petition, my lord, if your lordship see the kind of allegations made against his former father-in-law, he accused him of murder of his own son.
Where is the document? Where is the evidence? These are all, right, this.
Please see, my lord, if my learned friend
The
is.
father of the
saying-
wife for every.
No, I
application.
think we are expanding the scope of the writ petition itself.
Correct.
Please come to the judgments. Which one you're relying on?
No, my lord,
Because on some judgment.
now that he has submitted about the mediation, visitation rights,
Hmm.
they did not honor the orders of the honorable court.
Hmm.
They did not encourage me to meet my children
Hmm.
because children were brainwashed.
Yes.
The children were told that the father is a devil, father is a murderer. Therefore, the fact that I went to the director in the family court, requested him to appoint a mediator to supervise the visitation rights. I will just read a letter that mediator who was appointed to supervise the visitation rights has written a letter to the director. I have not.
That's what
produced
is
it.
extracted, that I.
No, this is a letter by mediator who was appointed to supervise the visiting rights. Here, 2 minutes, one second. The respondent is not bringing the children for visitation as directed by the honorable court. Since last month also, on last Saturday of the month, 25/10/2014, I waited till 4:30 PM, but they did not come. Today also, they have not come. Request you to acknowledge these absence so that I can produce some in the court. This is by the Deputy Director, Mediation Center. This is the report he has given. I have not produced it, but I have got a copy. I will produce it.
Yes.
So everywhere they have frustrated me. Everywhere they have blamed me. See, if that was the case, they inflicted on me this inferiority complex. I am the High Court judge's daughter. I can send you to jail. She went to the extent of beating my old 80-year-old mother. It was at that time I did not throw her. I took her in my car and left it in Justice Anwar's house. I did not throw them. They are not small people to be thrown. They are all educated and influential. She could have simply called a cab and gone. This is a story they are making. If your lordship permits me, as your lordship said, if this writ petition does not enlarge the scope for adducing all the facts that I have transferred in the trial court. If only time is given, I will be able to convince what are the hardship I have gone through. She is also
Let's look at the legal position.
No, I'll come to the points, my
orders.
lord.
Yes.
Number one, your lordship may see my paper.
Yes.
My paper book, page number 9. That's the order of the trial court. I'll confine to legal matters.
Yes.
First order. The petitioner is hereby directed to pay an amount of 1,98,397 to the respondent, which was school fees. This application was made before the trial court also. That order I have produced. Trial court said this is not permissible. There is no law in the Family Court Act to provide school fees because it is part of maintenance. So it came to be rejected. When this visitation rights was frustrated, for about 1 year, I came regularly to see my children. They did not talk to me. They were held back by the wife, by the mother. They are living with the mother. So therefore, logically, psychologically, they will be moved towards the mother. On that frustrated date, I filed a memo and said, I want to withdraw this GNWC. The fact that I have applied for GNWC, namely, the fact that I wanted the custody of my children shows my bona fides and falsifies their case. I apply for custody of the children. You did not. You went on proving the case for 12 years, 13 years, 14 years, accusing me. Even day before yesterday, you file an application and say that this lady, this first girl who is 24 years, she completed her BE in distinction. There was a campus selection. She was selected by international company. She was paid 1,50,000 as admitted by them. Now they want to send this girl to Florida, USA, and want me to pay 4,80,000 per month. Is it logical? Is it ethical? Is it legal, my lord? I may be pardoned to say this, my lord. They are trying for a ransom. She married another person who was 60 years retired, Deputy Commissioner of Income Tax. And she comes and tells the trial court, luckily I am married to a rich man. I'm living in a big bungalow. My children are looked after by them. Is this how you come to the court and say? What it shows? It demonstrates, it depicts your arrogance, your egotism, your despotism. That's what you did for me. Otherwise, why would I leave you? I would have happily lived with you. And this, we would not have come to this position of sharing my income. I am getting 84,000, my lord, per month. I have my wife. I have married again. I have two children who are 10 years and 9 years old. They are admitted to the schools. And I have a widowed mother who is bound by wheelchair with all comorbidities. I have to look after them. When you filed 482 dowry harassment against me.
Now,
There my brother died. That still is going on. You went to domestic violence.
We are in a maintenance matter. What is wrong with the order passed by the court below? Please tell the court. Only on the merits of the matter, because we do not
Is
have.
not relevant, my lord. You filed dowry harassment case against my mother, my brother who died, and his wife and children I have to look after now. Now, apart from that, my lord, you went to domestic inquiry, domestic violence act, where you suppressed the matter that you have divorced me. If you had told the matter that you have divorced, section 12 of the domestic violence act is not applicable. When I went there and filed my wakalat and brought to the notice of the court that when once divorce is there, maintenance, domestic inquiries does not survey, therefore they dismiss. Dismissal order, they challenged it under section 49, 89. Went to the district judge and said, the word dismissal should not be there. It has become infructuous. Therefore, 4 years I had to drag on. This is the conduct of the persons. Now I'll come to the order, my lord. First order is 1,98,000, which I submit with great respect, is not exclusive of the maintenance.
Next.
It is an integral part of the maintenance.
Yes.
Number one. Number two, petitioner is also directed to pay 3,21,000, which I have paid arrears with great difficulty. I had paid 1,44,000 in that criminal proceedings where 6,000 was ordered by this honorable court.
Yes.
Later of this order, I told my client, this is arrears of rent. I have admitted it and I had acknowledged it.
Yes.
I paid 3,21,000, my lord. That I have no grievance, my lord. The third one is the my important submission. Third one is petitioner is also liable to pay 8 lakhs each to the children for their marriage expenses. This is my important submission. Nowhere there is maintenance order for the children, especially for major children. No act enunciates, emphasizes, or orders, makes an order. There is no law asking me to pay marriage expenses.
Yes.
Number one. Number two, for major children who is 24 years now, I do not know whether she will marry or not. It is only a hypothecated version of the trial court. We don't know. It's a contingent feeling. She may not marry, but still you want me to pay? That is not my ground before my lord. My ground before my lord is a major daughter, earning daughter is not entitled for marriage expenses. To support, I have produced 3 judgments, given the copy. The first page itself says, my lord, Supreme Court holds a major daughter not entitled to education expenses from father as she does not want to maintain relationship with him.
Yes.
My emphasis on this, my lord.
Yes.
Even yesterday when I received this application by my learned friend, I called my client and showed it to him. He was only tears in his eyes and nothing else, no answer. Because she passes BE, she doesn't inform me. She wants to go to Florida, doesn't inform me. She is not a child. Minors, mother will represent, no doubt. Minors cannot say anything. Now she is 24 years, my lord. Could she not have telephoned to me? Could she not have sent a message? Papa, I am going for Florida. I want your blessings. But still you want the 8 lakhs from me for marriage, which is contingent. I invite my lordship's kind attention to
Ajay Kumar Rate.
first judgment.
Yes.
page number 9,
Yes.
8, 9.
Hmm.
Last but one para.
Hmm.
I have marked it, I think.
Yes.
Insofar as the daughter's expenses for education and marriage are concerned, it appears from her approach that she doesn't want to maintain any relationship with the appellant and is about 20 years of age. She is entitled to choose her own path, but then cannot demand from the appellant the amount towards education. We thus hold that the daughter is not entitled to any amount, but while determining the amount to be paid as permanent alimony to the respondent, we are still taking care to see that if the respondent so desires to support the daughter, funds are available.
Yes.
My lord, that is in a case of permanent alimony for wife. That is what now my learned friend will bring in that famous case, Rajesh case. She is a part of alimony includes marriage expenses. That is alimony. That is a lump sum payment to the wife. Here wife is
Already divorced.
already
now.
having a.
Yes, next judgment at page 12.
Now
High Court
I'll
of
read,
Bombay.
this is the first judgment, my lord.
Then High Court
Second
of Bombay.
judgment, I'll bring it to your lordship's kind consideration.
Para 28 and
Para
30.
20, my lord.
20.
20, para 28, your lordship.
Yes.
With regard to the claim of rupees 16,000 by way of marriage expenses, the learned judge in answer and discussion of issue number 5 has rightly held that Babai, daughter, was a married daughter and that unmarried daughter, second one, if adult, unmarried daughter, if adult, unmarried, cannot claim maintenance under section 23 of the Hindu Adoption and Maintenance Act. I see no reason to hold otherwise with regard to this item. Then the third judgment I would quote to my lordship's kind consideration is page 22.
Yes.
Head notes.
Yes.
A Hindu Adoption and Maintenance Act, Hindu Minority and Guardianship.
Yes.
Sued by minor represent next friend for maintenance against father, maintainability. Next column, my lord. The expression maintenance is defined in subclause B of section 3 of the Maintenance Act to include provision for food, clothing, residence, education, medical attendance, and treatment. It is nowhere stated for marriage expenses.
Yes.
The inclusive part of the definition relates to the basic requirements in life, and neither of the parents is entitled to escape this liability. These are the judgments that I bring it to your lordship's kind consideration for denying them. I am not liable to pay them.
Yes.
In fact, the Ketinoff decisions I have culled out and made it short to put it briefly. My lord, this is what Supreme Court says.
You can pass it on to the court. Will,
There is no illa nando. This is my notes. I'll just quote this, just for my lord's kind consideration. There is no straitjacket formula for fixing quantum of maintenance. A careful and just balance must be drawn between all relevant factors. The maintenance awarded must be reasonable and realistic, and avoid either of the extremes. That is, maintenance awarded to the wife should neither be so extravagant, which becomes oppressive and unbearable, like arrears of maintenance, school fees, marriage expenses for the husband.
No, without
Nor
a
should it
citation,
be-
Mr. Counsel, without a citation, just like that, you can't read the notes.
Yes.
Those are all the settled law. Now, as far as on the merits of it, you have advanced your arguments. Court
Yes.
has noted down. Anything?
Yes, I have.
Yes.
May I just, in Islamic law, what the position is, that a father is liable to maintain the daughter till she marries. May I just pass on that judgment?
Yes.
Noor Sabak, I think. Yes. Noor Sabak.
Yours.
Yes.
Para 9 and 10, my lord, at page 239.
Yes.
And finally, my lord, if your lordship sees 10, I'll just read 10 because 9 is the extract of Muslim law. Thus, both under personal law and statutory law. Para 10 is 240.
Yes.
Thus, both under personal law and the statutory law, the obligation of a Muslim father having sufficient means to maintain his minor children unable to maintain themselves till they attain majority, and in case of females, till they get married is absolute, notwithstanding the fact that the minor children are living with a divorced wife. That's one. And then, Lord, your lordship may kindly see the judgment in Rajnesh's case.
Check that.
Good. Okay.
Yes.
Para 91, my lord. As to what is this maintenance, my learned friend asked, saying there is no definition. Para 91 at page 375.
Yes.
Living expenses of the child would include expenses of food, clothing, residence, medical expenses, education of children. Extra coaching classes or other vocational training courses to complement the basic education must be factored in while awarding child support, albeit it should be a reasonable amount to be awarded for extracurricular coaching classes and not an overly extravagant amount which may be claimed. Education expenses of children must be normally borne by the father. If the wife is working and earning sufficient, expenses may be shared proportionately between the parties.
Yes.
And in the previous paragraph, my lord, para 90.4, an able-bodied husband must be presumed to be capable of earning sufficient money to maintain his wife and children. Cannot contend that he is not in a position to earn sufficiently to maintain his family, as held by the Delhi High Court and so and so. Onus is on the husband to establish with necessary material that there are sufficient grounds to show he is unable to maintain the family and discharge his legal obligations for reasons beyond his control. If the husband does not disclose the exact amount of his income, an adverse inference may be drawn by the court. Court in so and so cited the judgment in so and so with approval and held that the obligation of the husband to provide maintenance stands on a higher pedestal than the wife. And from what date it should be awarded? It is from the date of the application. That is what Supreme Court has said. And Lord, he himself in his affidavit filed before the court, I'll just please see page 57 of the petition, Lord, what he has said.
Yes.
Of my petition, page 57. I'll just read 2 paragraphs more. He says, I am desirous of and capable of educating my daughters in any professional stream. And I'm desirous and capable of conducting and celebrating the marriages by meeting high-end expenses with any good and high-profile family. I don't know. Marriage need not be with any high-profile family. It has to be with a good man.
Yes, that is when you give me custody. That was the application for
These are
custody, wherein I have stated, I am ready to take care of them, give my education to the best of my ability. A tailor's son cannot send his daughter to Florida. He can send her to St. John's School or National High
Yes.
School.
Lord, I think, Lord, obligation of a father is to the children. Mother is not asking for, or the wife is not asking for money. I can understand all these allegations against the mother. But children are saying, I have to be educated. Mother has taken money from the father and the brother to educate. Now it is your obligation to pay. And the entire expenses which we have listed out, and which, my Lord, your lordships will find, which we have pointed out in the petition from page 127 onwards, has not been disputed at all. Not a single question, even in cross-examination, challenging any of it.
Yes.
All of that, no, actual expenses incurred. We are not asking for anything more. Pay those expenses so the children are, at least the children have the money, and I repay my father and my brother. And all these arguments, my Lord, that he is a judge or whatever he may be, he is also a grandfather. So he has undertaken that obligation of educating the children, ensuring that they come to this level, which the father has not. And on 2014 onwards, he's not even bothered to look at the children till now.
Yes.
2 important things I forgot to submit before your lordship.
Please, sir.
When a compromise meeting was held
Yes.
by a registrar of this honorable court, she demanded all the jewels that I have given to her, the jewels that they have given to me, and the gifts we got. If I am not mistaken, gifts were in plenty because a high court judge was celebrating his daughter's marriage. Everything she took it. She did not bother to give me a single gift packet. And here is the acknowledgement for having taken jewels worth 500 grams, which is now 30 lakhs. It's not as if I deny her this marriage expenses, she will be bereft of funds. She has funds. 30 lakhs is there available with her. This is her written.
Yes.
Then second important point that I forgot to mention with your honor's kind permission, with lordship's kind permission. Your Lordship may kindly turn to page 76. This is the application IA number 10 for maintenance. Has he spoken about, claimed or prayed about the marriage expenses? No. Application 11 for school fees. Has he claimed about the marriage expenses? Is there a law? Was there a pleading? There is no law. There is no pleading. There is no prayer. Therefore, there is no adjudication. I was unable to answer that. If he had pleaded, this is most important in my respectful submission, my lord, that throughout the length and breadth of your case, there is not an iota of mention of marriage expenses demanding. It is a trial court's ambition, trial court's feeling that it should
Yes.
grant this matter. Yes, maintenance, the
Yes.
marriage expenses.
Heard
It's
the
purely
counsel.
uncalled for.
Heard the council's result.
Great.
Who? Huh? Which one? What to tomorrow let it come? How many are there?
Lordship's kind leave.
Pronouncement.
Therefore, respondent. Nurse of 58.
That petition is dismissed.
Lordship's kind leave. Make a mention.
I appear for Remand matter.
Dismissed. Dismissed. All the 4 petitions, all are connected, don't have to call. 4 are connected, all are dismissed. Oh, that is different. What you've given is that
61.
the order passed in FDP number 1 of 2011 dated 24/1/2017 with the 3rd additional civil judge is set aside. And the survey's report is also set aside. The court below is directed to issue a fresh warrant for execution of the decree, and basing on such report placed by the commissioner, subsequent steps are to be taken up by the court. That petition is allowed by setting aside the order in OS number so and so. Consequently, IA number 2 is allowed. That petition is dismissed with the liberty to avail the appropriate remedy. Yes. Tomorrow.
Lordship's kind leave.
Coming up in that dismissal list because there was no appearance on 10th of June. Thereafter, the matter has been heard on 2 occasions. May I request the matter be listed in the B group? 31.
Deleted from the caption for dismissal. Yes.
May I request Monday. Notice.
Monday.
Monday number 25.
Serial number 38, madam. Serial number 38.
How can it be? Then engage a counsel who is available next week. Now, on these grounds, if you have an opportunity or this thing to avail a counsel who is available, if an advocate on record is unwell, they will be accommodated, not for a senior counsel, not before this court. Yes.
Serial number 30.
Serial number 13, madam.
All these matters or will be accommodated on, according to the family court and CPC, she'll tell that. Anything which can't, in any urgency other than that, please tell.
Lord, serial number 43, my lord. I'm appearing for respondent number 3. I have just filed my wakalat today, my lord. My lord may kindly direct the petitioners to furnish a copy of the petition copy and along with the annexures, my lord. In 3 weeks time may be granted. I have to apply for trial court records and have to obtain.
What is that, CPC or FC matter?
CPC.
Huh?
CPC.
Which year is the matter?
19.
2019 matter, you will seek 3 weeks?
My lord,
Sorry.
apologies, my lord.
Lordship,
My lord,
Lordship,
You will
kindly
give the
please.
papers, that will be there in the list.
Serial number
My lord, my
47.
submission is the client has approached me yesterday, my lord. I do not have the trial
Your
court
client,
records.
why he approached you yesterday in a matter of 2019? That is your client's
I
problem.
have a valid explanation for that.
That we will see when the matter be, when
Mainly 2 weeks.
when we look at the file, then we will see. To know 2019 matters will be adjourned inordinately like that.
2 weeks.
Yes, no.
I will apply.
I filed an application yesterday for paper publication for respond number 13 because it was not served on them. Now he has not filed wakalat. He has filed wakalat, so it may be dismissed.
So you, both of you want everything to be done now at this hour, without a paper, without file. It will come, we'll see.
The contesting respondent, my lord, the order against me.
In this case,
Please, kindly fix the date, my lord, next week, my lord.
so it will come. All the dates, for in the next coming week, all the CPC matters on a CPC day, FC matters on a FC day.
My lord,
Next
14 and serial number 14 interim order may be extended.
No, interim order is granted in the next date of hearing. Now it is not heard. That means your interim order is subsisting. Is it not?
No, last date it was, I was unable to appear in.
Then it will not be done now.
My lord,
How can it be done now?
no, my lord,
If on the last occasion, if you have not come, then the court has not extended the interim order. Now, when it is not done last occasion, why will do it now?
dated so and so, interim order dated past dated so and so, 18/1/2023, my lord, may be considered.
Take out this file and show me what is it will say.
Lordship, serial number 31, the senior is a mediator trainer.
Huh?
The senior is a mediator trainer. Next week she has trainings and hence she has requested to avoid next week.
To avoid?
The senior is a mediator trainer in serial number 31. My junior got confused. We are not engaged in any senior counsel. The senior advocate is a mediator in 31. So kindly not have next week. Lordship. Any day after that or before that also we are fine.
No, even if every advocate has to understand this,
But also
you
we are
have to
fine.
make your order. It should be okay with the court also. Court has so many work.
Normal request.
No. But what to do? No,
Very
if anybody has any difficulty, you can engage somebody else, then that's better.
She's the
Or,
advocate on record.
or you can actually, anyway, you're asking a adjournment, you can as well argue that day.
Cannot be on Monday, Lordship. She has specific.
The whole week it is not possible. If not Monday, then Tuesday it will
At
come.
least Thursday next year, Lordship. Next Thursday.
Post on Thursday, that matter number, your case.
Serial number 38.
Madam, case 46. Madam. Madam, serial number.
Madam, serial number 25 outdated.
Madam, serial number 39, extend ಆಗ್ಬೇಕು ಐವ extend ಆಗ್ಬೇಕು 39 ma. Yeah. Please.
ನಾವಿದ್ದೀವಿ ಮೇಡಮ್, ಯಾವ್ದು ಡೇಟ್ ಹಾಕಿ? 8 ಹಾಕಿ. ಮಂಡೇ 9/7.
ಒಂದೇ ಒಂದು ನಿಮಿಷ ಒಂದೇ ಇರ್ಲಿ.
Dear petitioner. 29.
29 ಅಂದ್ರು 54 ನಮ್ದು.
29.
28 is on 11/7. So then the 27 is also on 11/7. 29.
Madam, petition.
You will get 27. 11/7. 11/7.
Serial number 43.
30, I am respondent, 9/7. Issue Baba, 9/7. 9/7. Still number 31 adjust to 11/7, 32. That is EMFC, Monday. 8/7, 33. That is EPC 11/7. ಅದಕ್ಕಿಂತ ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಹೇಳ್ಬಿಡ್ಬೇಕು. Still number 34.
I appear for the petitioner. Interim order is to be extended, ma'am. Interim order is to be extended in 34.
Interim order, the man is there is a specific instructions until that matter is heard. Interim order not extended. So if that release means substance. Tell number 34. EPC 11/7.
ಆಯ್ತೇನಮ್ಮ?
Sagar PP 35. 11/7 36. 37.
Ma'am, 36.
37.
Dismissal withdrawn, 36.
38.
2 weeks, sorry, madam. Madam, 2 weeks.
No, 8/7.
1 week, one week.
37 Pravinesh alva?
No, after 1 week.
Petitioner ಇಲ್ಲೇ ಇದೀನಿ, ಮಂಡೆ
Friday
ಹಾಕಿದ್ದು.
ಕೊಡಿ.
ಮೇಡಮ್, ನಾನೇ petitioner ಮಂಡೆ ಹಾಕಿದ್ದು 8/7.
8/7. Tell number 39.
ಅಯ್ಯ ಟಿ ಆಕ್ಷನ್ ಆಗಬೇಕು. 12/7 ಕೊಡಿ. 12/9 MC 19/7 ಕೊಡಿ. 8 ಮೇಡಮ್ ಇರೋಲ್ಲ ನಾನು. 10/7 ಮೇಡಮ್ 3 ದಿನ ಇರೋಲ್ಲ ನಾನು. 12ನೇ ತಾರೀಕು ಕೊಡಿ. 12th ಕೊಡಿ. ಮೈಸೂರು.
Number 40, EMCPC. 41. 42.
petition.
11/7.
43 ನೋಡಿ.
43.
ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಡಿ. 11/7.
11/3.
ಅಪೀಲ್ ಅದು.
ಇಲ್ಲ ಅವ್ರು ಒಕ್ಕಲತ್ ಹಾಕಿದ್ದಾರೆ ಒಕ್ಕಲತ್.
But the paper publication IN has updated.
ಆಯ್ತು. ಅಲ್ಲ ಅದರಲ್ಲಿ 4 and 5 ಗೆ ಸಂಜೀವ್ ರಾವ್ ಹೆಸರು ತೋರಿಸಿಲ್ಲ ಮೇಡಮ್. 4 and 5 ಗೆ ಮೇಡಮ್ 4 and 5 ಗೆ 43.1 ಅದು ಎರಡರಲ್ಲಿ 4 and 5 ಸಂಜೀವ್ ರಾವ್ ಹೆಸರು ತೋರಿಸಿಲ್ಲ. ಸಂಜೀವ್ RIL ಅಂತಿದೆ. ಅದು ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿದೆ ಅಷ್ಟೇ. ಹಾ ಓಕೆ ಓಕೆ ಓಕೆ.
43, 11/7, 44, 11/7.
ಮೇಡಮ್ ಅದು ಸ್ವಲ್ಪ ನಾನು ರೆಸ್ಪಾಂಡೆಂಟ್ ಅದ್ರಲ್ಲಿ ಅಲ್ಲ ಅದು ಮೇಂಟೈನಬಿಲಿಟಿ ಮೇಲೆ ಇದೆ. ಆದ್ರೂ ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ ಅದಕ್ಕೆ ಎರಡನೇ ಬರ್ತಾ ಇದೆಯಾ ಹಿಯರಿಂಗ್ ಅಲ್ಲಿ ಆದ್ರೂ ಹಾಕಿದ್ರೆ.
ಮೇಡಮ್ 46 ಅಲ್ಲಿ ಇದು ಇಂಟ್ರಿ ಆರ್ಡರ್ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಗ್ಬೇಕು ಮೇಡಮ್. ಎಲ್ಲ ಮ್ಯಾಟರ್ ರೀಚ್ ಆಗ್ತಿರೋದು ಆಟೋಮೆಟಿಕ್ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಅಲ್ಲ? ಮೇಡಮ್ ಸ್ವಲ್ಪ ವಾಲ್ಯೂಮ್ ಲೋ ಇದೆ ಮೇಡಮ್, ಕೇಳಿಸ್ತಲ್ಲ, ಸಾರಿ. ಹಾ ಅದೇ ರೀಚ್ ಆಗಿಲ್ಲಲ್ಲ ಮೇಡಮ್ ಅದಕ್ಕೆ. ಓಕೆ ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 54 ಯಾವತ್ತು ಕೊಟ್ರಿ?
3 ಸತಿ ಪೋಸ್ಟ್ಪೋನ್ ಆಗಿದೆ. ಹೌದು
ಮೇಡಮ್
ನಮ್ದೇ ಅದು
46.
ಹಾ ಎಸ್ ಮೇಡಮ್
46 ನಮ್ದು ಈಗ ಮಾತಾಡಿದ ಅದು ಮಂಡೇ ಹಾಕ್ತೀವಿ.
ಮಂಡೇ ಎಕ್ಸಿಡ್ ಸ್ವಲ್ಪ ಅರ್ಥ ಮಾಡ್ಕೋಬೇಕು ನಮ್ಗೆ.
Tuesday ಹಾಕ್ತೀರಾ?
Instructions ಇದೆ.
Tuesday
We have to follow the
You are 11/7.
It is of 11/7.
ಆಯ್ತು ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು.
Madam, serial number 54.
Serial number 4711 48 87
What of sir, madam?
49
One day FCL.
50
Madam, 54.
ಇರಿ ಒಂದ್ ಸ್ವಲ್ಪ ಸೀರಿಯಲ್
Given petition provide.
ಅದು ಕೇಳಿಸ್ತಾ ಇಲ್ಲ, ಅದಕ್ಕೆ ಕರೆದೆ ಮೇಡಮ್, ಕೇಳಿಸ್ತಾ ಇಲ್ಲ.
87 53 94
54 ಯಾವಾಗ ಬೇಕು ನಿಮ್ಗೆ? ಇಲ್ಲಿ ವಿಸಿಲ್ ಇದಾರೆ ಮೇಡಮ್ ಅವರು.
ಮೇಡಮ್, 2 weeks. ಅದು 2 weeks ಕೊಡಿ ಮೇಡಮ್.
2 weeks ಅಲ್ಲ ಸರ್, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಹೇಳ್ಬೇಕು.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ 12/7 ಕೊಡಿ.
10/7 ಸರ್.
ಓಕೆ, ಆಯ್ತು ಮೇಡಮ್.
55 57 ನಾಳೆ ರಿಪೀಟ್ ಮಾಡಕ್ ಹೇಳಿದ್ದಾರೆ.
ನಾಳೆಗ ಇದು ಇದೊಂದೇ ರಿಪೀಟ್ ಕೊಡ್ಬೇಕಾಗಿರೋದು. ಒಂದ್ ನಿಮಿಷ ಹೇಳ್ತೀನಿ ಸರ್.
58 ಇಂದ
ಅದ್ ಮುಗೀತು ಬಿಡಿ ಅಷ್ಟೇ.
ಮೇಡಮ್ 63 ನೋಡಿ ಏನಾಯ್ತು?
ಪ್ರವೀಣ್ 87. 37.
ಆರ್ಡರ್ ಏನಾಯ್ತು?
37 87 ಹಾ?
ನೋಡ್ಕೋಬೇಕಂದ್ರ
33 ನಾ? 33 11
ಫಾರ್ಮಾ
ಇದೊಂದೇ ರಿಪೀಟ್ ಮಾಡ್ತೀನಿ ಮೇಡಮ್. ರಿಪೀಟ್